accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually indicating that this meeting would take place at the town hall at 7:30 p.m. on Wednesday, January 17th, 2024. Roll call.
Corey Biller.
Here.
Allison Canfield.
Here.
Michael Cohen.
Here.
Gaston Halbert.
Here.
Deborah Nevis.
Here.
Frank Saccomondi.
Here.
Sujata Shan. David Cosgrove.
Here.
Michael Zion.
Here.
That's all.
Here. Before we begin with any applications tonight, we're going to start with our memorializing resolution. Right, for the resolution of the planning board to approve professional services by our board attorney as was introduced at the last meeting. And it is Savo Shock, where we will be represented by Stephen Warner, who joins us tonight. Welcome to your first meeting with us. What do we need to do in order to approve? We need a motion, a second, and then a roll call vote. Okay, great. I move to approve. Do we have a second?
Second.
Thank you, Allison.
Corey Biller.
Yes.
Allison Canfield.
Yes.
Michael Cohen.
Yes.
Deborah Nevis.
Yes.
Frank Saccomondi.
Abstain.
Sujata Shan.
Yes.
David Cosgrove.
Yes.
Gaston Halbert.
Yes.
That's all.
Yes.
Thank you very much for your confidence. Appreciate it.
Welcome you. As you may notice, the next two items that had been on our agenda are going to be deferred because we have not yet received the minutes of December 20th, 2023. Actually, it was a note I leaned to just wishful thinking. So we will go ahead and defer those until our next meeting or when we have them to distribute. Same goes for memorialization of application 23006, which you just received or we haven't received it yet. Okay. So as soon as those are received, they will be distributed for our review. That said, we will move next to our first and only application of the evening, application 23007, 85 Woodland Road. This is for amended preliminary and final site plan approval. And before we commence, I know we do have a few recusals from members of the board. We have recusals from Mr. Cosgrove, Ms. Nevis, and Ms. Canfield, who all had previously, during the application, the initial application, had participated, not as planning board members at the time. So in order to eliminate any appearance of conflict of interest, they have chosen to recuse for this evening. We would have you wait out in the other room, and we will call you back certainly for the latter part of the meeting.
TV.
And there's a TV in the cafeteria.
Bar.
Not anymore.
Okay.
Madam Chair, with your permission, while counsel and the applicants are preparing, I did have an opportunity to review the notice for this matter and the affidavit of service and publication. I found the content of the notice to be sufficient, found it to be timely served and published both on January 5, both of those at least 10 days prior to this evening. So the board does have jurisdiction to hear the application and decide this evening should it conclude this evening.
Good evening, everyone. It's a pleasure to be back here in beautiful Melbourne in person for my first time in a while. My name's Derek Orth, and I'm from the law firm of Inglesino Taylor, and I'm here on behalf of the applicant, 85 Woodland Road, LLC. We are here tonight seeking your approval for two relatively minor items. As I'm going to get into greater detail, we are seeking amended approval so that we can locate our transformers outside the building, which the board previously approved, as is required by JCP&L, the utility. Secondly, we are also seeking an extension of the period of protection for these approvals for 1 year, which would run through October 5th, 2024. A little bit of background on the subject property. I see a couple new faces on the board, and I welcome you. Also, congratulations to Mr. Warner on his appointment. So the subject property was previously identified as block 1904, lot 72 to 75. It has now been consolidated into lot 72.01. The property was previously occupied by a Texaco gas station and a few ancillary structures. Most of the structures located on the subject property have been demolished, excepting the Summit Medical Office Building. As the board may recall, this property was rezoned back in late 2019 pursuant to a Mount Laurel settlement agreement between the applicant, the township, and the planning board to permit a 62-unit inclusionary community along with 10,000 square feet of medical office space. The applicant filed an application requesting preliminary and final major site plan approval with bulk variance relief in June of 2020. Following 9 public meetings, which I had the pleasure of being at too, the board approved the application on or about May 5th, 2021, and granted the applicant site plan approval along with bulk variance relief for a required width of an upper story step back and also a temporary shortage of parking during the construction of the project. The parking variance was required at the time because the project, as initially contemplated, was proposed to be constructed in phases so as to permit Summit Medical to continue its operations during construction while their new space was being built. The resolution of approval for the project was memorialized on or about October 5th, 2021, which is where the one-year extension date comes from. Post-approval, the applicant pursued all of the necessary outside agency approvals for the project. I laid these out in one of my letters to the board, but briefly, we have obtained approvals from the Soil Conservation District, the DEP, the county, who issued a letter of no interest, the township's pedestrian safety board. We also have obtained a TWA permit. The board has signed the plans, and we even obtained a demolition permit. Now, we ran into one major issue during resolution compliance and outside agency permitting. Specifically, JCP&L will not permit the applicant to locate the project's transformers, and there are 2, as our witnesses will testify, inside the building. As the board may recall, we had testified during the course of the prior application that the transformers would be located inside the building. We fought the good fight with JCP&L over the course of the past year, but they would not budge. I obtained a letter from JCP&L dated July 27th, 2023, which was included in our application packet. That letter states as much as I have just said, which is that JCP&L's requirement is that the transformers be located outside the building or else they will not energize the building. So in other words, we need the board's approval of this amendment in order to construct this project. Our professionals will describe the plan revisions, but briefly stated, we cut into the previously approved building footprint in order to locate the transformers outside the building. We had to reduce our building coverage in order to accommodate this change, and we made a few very minor modifications to the building footprint. That said, the transformers are located within the previously approved footprint for the project, and we are not violating any of the setbacks which were approved by the board. So one last item before I start introducing my witnesses. I want to update the board on a recent development with the project. Summit Medical will no longer be occupying the 10,000 square feet of medical office space. Just by way of news reports that I have read, Summit Medical was acquired by Village, I can't remember the name, but major medical conglomerate, and they are in the process of merging operations. They still have a lease for their existing building on the property, but our expectation is they will vacate that space in the coming months and formally terminate their lease. The upshot of all of this is that we will most likely no longer need to construct the project in phases. Rest assured, we are still constructing the medical office space, but we'll need to find a different tenant. So now that I've spoken for far too long, I'd like to introduce my witnesses. I'm going to start out with Michael Lanzafama, who I'm sure the board is well familiar with. He is our civil engineer. Mr. Lanzafama is going to present an exhibit which superimposes the new building footprint on the previously approved plans. Second, our project architect, Rob, where are you? There he is, Robert Waldron, who's going to present elevations and renderings of the exterior modifications to the project as a result of the relocation of the transformers. So with that said, Mr. Warner or Madam Chair, if however you'd like me to have my witnesses sworn in.
I'm fine to go ahead and swear them in individually. I would like to request as we move forward, if we can address the checklist waiver items. I believe there's an EIS waiver request.
Yes.
So we can do those upfront to make sure we're gonna proceed into the application, follow in that process.
Yes, we
So I don't
could.
know if you have somebody specifically that you wanted to testify to that. I would say that. person
I
would be first.
Did not. It was my understanding the application had been deemed complete,
Okay,
which
so we
I
don't need to.
understood that the waivers were
I
granted.
haven't been given the, that would be our engineer or planner would know, but I wasn't given information that it was deemed complete or that it was not deemed complete.
Yeah, I deemed it complete because did you request a waiver? If they requested a waiver for the EIS, that was in the application.
Right, typically, as we get them, we receive it, and there may be a checklist waiver request item, then we usually just request simple testimony to clarify why, and then we would, as a board, vote to approve that waiver request.
If there were any other waivers requested, you could do that.
I don't
with all
believe so,
of
I
them.
don't
That's the only
see,
one.
Eileen, usually like behind the front application sheet, they typically have it.
Certainly should be something that the
I think Mr.
engineer can
Lonzafame
testify
provided
to.
it in the past.
We did submit an EIS with the initial application. I can
Oh,
cer-
okay, so it would be the
That's-
same because there's no
Correct.
change from the initial application.
Correct. The only change to the project is the relocation of the transformers.
Okay, I just,
Right.
as I see on the second page of the letter, it mentions the EIS waiver request.
Yes.
So, I just want to make sure we're following due process.
No problem at all.
So if it was previously awarded.
If you're relying on the prior EIS and the engineer, and I'll swear everyone in a moment with your permission, Madam Chair, but could weigh in as to the appropriateness, and the board can render determination if that waiver request should be granted this second time around, if you will, reliance on the prior EIS for this application.
I prefer we do that, yeah. Okay.
With your permission, I'll swear in the applicant's witnesses as well as our two board professionals, as is my practice. I swear in our board professionals every application. So if you'll all four of you raise your right hand, I believe we have two witnesses for the applicant. Do all four of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you all. We can proceed, Madam Chair.
My name is Michael Lanzafama, that's Lanzafama. I'm a licensed professional engineer, land surveyor and planner, licensed in the state of New Jersey. I'm a principal with the firm of Casey and Keller Incorporated, 258 Main Street, Millburn, New Jersey. I've been licensed as a professional engineer and land surveyor since 1984 and a professional planner since 1985. I was the engineer on this project back in 2020. And as Mr. Orth pointed out, that we did prepare an environmental impact statement back in April of 2020.
Wait, can I pause?
Oh, yes,
Before-
sorry, I'm just on a roll.
I know, I see that. Are your, all of your licenses up to date?
Yes, they are, they're current,
Okay, we will hear you as an
as
engineer.
an
tonight.
engineer today.
Okay, thank you.
You're welcome.
Now go ahead and proceed.
Certainly. So the waiver request for an environmental impact statement was made because the initial application did submit a very detailed environmental impact statement back in April of 2020, I believe was the date on it. I prepared it personally, and the elements of the environmental impact statement are not being changed as a result of what we're asking for this evening. So therefore, we would ask for a waiver of a resubmission of a new environmental impact statement.
Okay, does anybody have any questions for Mr. Lanzafama regarding that testimony on the request for an EIS waiver? Okay, I move to permit us to continue hearing the application by granting the waiver request. Do we have a second?
I'll second.
Eileen, I think we'll take a roll call.
You can do a roll call. This is not a formal motion. It's just it's only with respect to the checklist waiver request.
Okay, all in favor? Aye. Any opposed? Okay.
Thank you very
for
much.
hearing. Thank you for allowing us to go through that process.
As Mr. Orr pointed out, we brought an exhibit this evening, which I have mounted on the easel to my left. I've brought in reduced copies. It'll be a little easier for board members
With the chair's permission, we can mark it Exhibit A1.
Mr. Lanzafama, are you distributing A1 or is this another
A1.
exhibit?
This is
Okay.
a reduced version of A1.
Okay.
Might be easier to just
I'll
take
take
one
them.
and pass it around.
Mike, if you want to just identify a date
Sure.
on that exhibit.
Sure. What has been marked as A1 is a copy of the approved site plan, which had a date of April 14, 2022. And what we've done for tonight's hearing is we've superimposed in red the outline of the building footprint as it has been currently designed. As you are aware, when we come in for site plan approvals, the architectural plans are not fully engineered. Well, the luxury you have of this evening's application is the building has been engineered structurally and mechanically, so that there were certain little adjustments that had to be made to the building for certain column supports and wall supports. So you'll see that the footprint is slightly different than what was approved on the perimeter. But the points of interest are two. Along Chatham Road, in the front of the building, you can see where the proposed transformer area is indicated. And the red rectangular area is the area that's been cut out of the building to allow for the location of the transformer, which is the dotted rectangle. We had to have a minimum amount of clearance around that structure as required by JCP&L, and it had to be open to the air vertically. To screen that from the street to make it look like what we had presented under the original hearing is the wall that faces Chatham Road matches the facade of the building. It's going to be brick and the same materials. There will be a solid fence gate, metal gate, that will screen the transformer from the street and allow for access by JCP&L via grass pavers that will be installed between the edge of the sidewalk and the gate itself. So a truck, if it needs to get in there, excuse me, a crane or a truck needs to get in there to service the equipment, they will be able to do that. And the gate is going to be very similar to the garage door opening, so it blends in well with the facade, and you'll see Mr. Waldron will present some exhibits that compare the original facade elevations, the renderings that were presented at the 2020 hearings, and the current configuration. You'll see how similar the building does, in fact, look. The second transformer is located in the southeast corner of the building along Woodland Road, and the same applies. An area of the building has been cut out to allow for the placement of the transformer in that location so that it's easily accessible from the street and has the adequate clearances that were required by JCP&L. These cutouts in the building result in the building being reduced by about 1,100 square feet. Other than that, no other changes have been made to the plan with regard to overall lot coverage is the same. The utilities coming into the building are the same. Water, gas, electric, sanitary sewer are all exactly the same number of units, same building height, same stormwater management system, the dry wells that were proposed at the southern end of the building. As Mr. Orth pointed out, we have all our necessary permitting from the state of New Jersey for sewer and for our flood hazard permit, individual flood hazard permit to develop within the riparian zone of the stream. So all of those are in place, they're valid. The flood hazard permit is good until 2027. The sanitary sewer extension permit does run out in the spring of this year. However, we can apply for another 2-year extension with the state. And that's where we're at.
Okay, does anyone on the board have questions for Mr. Lanzafama based on the testimony?
Yes, sir.
Do the transformers give off any emissions, whether sound or gas or anything else?
No, there's no emission. They might make a slight humming noise, but they're contained within the enclosure, would keep that. It's really a very minimal amount of sound. We had numerous negotiations with J.C. Penney, discussions, alternate ideas, trying to put the transformers underground, if not in the building. And this was the only way that they would be willing to work with us on this, was to have the transformers outside. You know, your only other option are numerous poles along the street with the can-type transformers, which obviously is not what we want in this area.
Was something changed between the design and present time that they wouldn't grant the approval? Like, I guess I wonder why we would have initially had a design.
Well, the bottom line is that we hadn't engaged them thoroughly, other than asking for the fact that they could service the building. We never got into the question of whether or not they'd be willing to we never asked the question until after we had our approval, and then we got into it. We have done transformers with PSE&G, for example, in vaults or inside buildings in more urban areas like Hoboken and Jersey City. However, JCP&L just would not do it.
Gotcha. Any questions?
Regarding the sound and noise, is the facade or the door, whatever blends in with the garage door, does that have any sound attenuation capabilities if the humming noise does prove to be audible?
It's a metal gate that is slightly louvered to allow for airflow. I don't know what the sound deadening capabilities of it would be, but I imagine something could be done. But it's such a low level humming that you might hear. It really depends on how it's functioning. So I couldn't tell you whether or not what the decibel level would be at the street, for example, but it really would be minimal.
Okay, 'cause, yeah, if we could have something in there where it would be fixed, because it is directly across from the apartment complex. Just looked on the map too, that we're directly across from the building. So if it does bother them, something could be done.
It would not be a noise that would bother someone from across the street. You'd have to be standing right next to it.
This is on the side that faces across from the,
You're talking about the one on Woodland.
oh, down that one, I see. Okay. Sorry, I was looking on Chatham. Yep. Thank you. Okay, do any members of the public have questions for Mr. Lanzafama on the testimony he just gave? Great, I can invite you to come up. You can just ask the question. You don't have to get sworn in. You can just ask the question. But if you can do it on the mic so that folks can hear you who might be watching. If you could just say your name and address.
Yes, I'm Beatrix Shear. I live at 101 Oakview Terrace, Short Hills, which is right next to the project. And I am concerned about the sound. Where exactly is the transformer going to be on Woodland Road, or is it going to be in that finger that goes back?
I'm going to exhibit A1. We have one transformer located at the southern end of the building, right by the finger that you're referring to.
But not located in the finger part.
No.
Yes, but it's on
And
Woodland.
then
It looks like
the
it's,
second on Chatham.
I'm just interested in the Woodland one. That's on Woodland Road.
Correct.
Okay, and would the sound, even though it wouldn't go across the street, would it emanate to the two houses closest?
No.
To-
No, it would not.
Okay, thank you.
Thanks. Other questions? Okay, thank you.
You're welcome.
Other questions? I'd like to call my next witness, which would be our architect, Rob Waldron.
Madam Chair, if I may, just for clarification, you're presenting both the request for the amended approval for the transformer locations as well as the extension. Are you doing that contemporaneously in this presentation, or do you intend to do it sequentially?
Sure. The testimony is going to be contemporaneous. I will ask the board for two separate votes at the conclusion of our presentation. There is a bit of legal argument with regard to the extension request. I'm just going to recite what the statute says the factors are for an extension request is all, which I would do after my witnesses testify on the amendment application.
Okay,
And Madam Chair, I have no objection to the procedure legally, and I think it's prudent that there be two separate votes.
understood. So one vote will be pursuant to the transformer change.
The
And then the
request for
second will
amended
be
approval.
on the extension of the time.
Exactly.
Thank you.
exactly. I do understand they're interrelated with respect
Yes.
to the operative facts involving JCP&L, so it makes sense to contemporaneously present it as well.
Does the sequence of those votes matter?
When you say matter legally, there's no requirement that one be
Would you
before the
advise,
other.
would you advise a certain sequence of those votes?
I don't see a problem with the request for the amendment first and the extension second. That's how I understood the applicant to make that request. The applicant does have the discretion to present
Yes,
the case in that way. So,
correct. It is my preference to ask for the vote on the amendment first prior to the extension.
Sure.
Okay. You should be sworn in.
Yeah, I'm just gonna move to this side. I hate to put it to anybody's back.
Yeah, if you want.
Except the whole audience will not be able to see.
I know.
So we might just want you to put it kind of in front of where that one is, if that's all right.
May we just?
Just, I'm gonna point it, so I'll
I
point
see.
and come back and.
No, it's better so the public can see if we can just move Mike's exhibit.
And you know what, the microphone will move, you can take it like a stand-up and have a grand old time. But we'll get you sworn in first. Oh, you swore him in, but we'll hear his,
Qualifications.
Robert Waldron from Michaels and Waldron Associates in Rivervale, New Jersey. I'm a licensed architect, I believe, for 15 years now. I'm not sure, somewhere in that range. And my license is in good standing.
And have you been qualified as an expert in the field of architecture in front of other planning boards in the state of New Jersey?
Yes, many.
Okay, can you name just a few?
Jersey City, Newark, tons in Bergen County,
Booton?
Boonton, just did.
And more.
Yeah, many. I've done thousands of residential units throughout New Jersey.
great, thanks. And did you participate in the design of this building, the architectural design?
So we did not do the original approval. We were hired to do the construction documents, and we are the ones that kind of uncovered some of the issues that needed to be, like, once you get to the point where you're, getting into more detail with the drawings.
Okay, we will accept you as your witness in architecture and we look forward to hearing your testimony and additional relationship to this project.
Okay.
Okay, so you should be able to remove that. Yep.
Yes.
And Rob, just,
I think it's stuck under here.
Mr. Waldron has a few exhibits which he has mounted on this board here. I have also printed out packets for the board to make it a little bit easier, but Mr. Waldron should probably identify the exhibits first before I start passing them out.
We can, or we can label each one as we get to it, whatever
Would
makes
you
the
like the
most sense.
packets now?
Sure.
Okay. Now, in my great excitement, I also attached Mr. Lanzafama's exhibit to the back, so that is just a duplicate.
We can pass them, it's cool.
Sorry.
Okay, well, there we go. Family style. Okay.
So the first drawing is actually a drawing that had been previously submitted that is in an exhibit, so it's not included in 11 by 17.
Okay, we'll label it as A2, right, because exhibit A2.
Well, was this submitted in the prior hearing?
No,
This is, let me,
Or it was submitted previously in connection with this?
it was submitted in
this
connection with this application.
And
I
it was
think it's the
submitted more
first,
than 10 days in advance of this evening?
yes, it was.
It does not have to be marked as an exhibit, just please clearly identify exactly what it is, the sheet, the last revised date, et cetera.
yes, this would be sheet A100 basement plan, and it's dated 6/21/22
Thank you.
with a, progress date of 10/9/23.
Okay, so last revised 10/9/23. Thank you.
So this is the basement plan, but actually in this section of the building, the basement is at grade level. So this is where Mike had shown that we had cut back the building to create space for the transformer, as well as gas and electric meters back here. And then we have enclosed that area with a wall which I'll show in the elevations in more detail, with 2 access gates in front. This is A101, first floor plan, with the date 6/21/22, with a progress date of 10/9/23. Again, this is all that, on this level it's showing is the continuation of the cutback of the building with the transformer area below. The second floor plan, which is A102, dated 6/21/22 with a progress date of 10/9/23. So it's the second floor plan, but is actually at grade along Chatham Road because there is a continuous slope as we get up here. So this is where we located the second transformer, and you can see we've cut back the building here, located the transformer and electric and gas meters behind the enclosure wall. This would be the first exhibit that we had not previously submitted.
If I may, Madam Chair, are we going to submit the balance of these as a compendium exhibit A2, or is each one going to be A2, A3, et cetera?
It'd be great if we could just mark it as A2 packet.
Okay. And how many pages is exhibit A2? 1, 2, 3, 4, 5, and we could ignore, I take it, the last page, which
Yes,
was
you
the
can.
duplicate
Yes.
in your exuberance. That's a 5-page compendium exhibit A2. If you could just identify it in a general sense.
Yes. Okay, so this is labeled Exhibit 1, and these are the street elevations. So along Woodland here, you can see the whole facade, and this is where the first transformer enclosure is located. And we have blown up that detail here so you can see it a little bit more clear. It will have a cast stone veneer with a cast stone cap and the black metal gate in front of the transformer. And this cast stone veneer you'll see is a continuation from the cast stone base that is located all throughout that building, so it continues straight through. On the Chatham Road elevation, you can see the whole elevation here, but this section here highlighted in the dashed box is where we revised it for the transformer, for the second transformer location. Again, we've blown up that area. You'll see a cast stone base with brick above and a cast stone cap and another black metal gate. And you can see in this area, the cast stone band is at this level and then brick and then a cast stone cap. So that's the reasoning for the different treatments of the 2 enclosure walls, just where they fall within on the building facade. So Exhibit 2 is a rendering, a current rendering of the Woodland Road elevation here. And you can see in this area here is what I was previously describing on the elevations is the continuation of this cast stone, which becomes the transformer enclosure with the black metal gate. Exhibit 3, which is our current Chatham Road elevation rendering. And this is where you see our second transformer location here. And you can see we've cut back the building for the open air that was previously described, and our enclosure wall and black metal gates there. Exhibit 4 actually shows the current rendering along Woodland as well as the previous rendering. And you can see same materials and design, cast stone bases, brick, cast stone window headers, banding, bays, all that has been kept. And you can see in the previous rendering that they had that same cast stone base, which we maintained and what we used to enclose the first transformer location. Exhibit 5 shows our current Chatham Road elevation rendering with the previous rendering below. And again, you can see we maintain the materials of cast stone base, brick sills, brick headers, the bays, the angled roof, the dormers, everything. We altered this area here to push back and continued that same brick and cast stone base with a cast stone cap in that area to enclose our second transformer. I think that's it.
If I may, Madam Chair, just to clarify the record, because you referred to all 5 pages of Exhibit A2 as Exhibit 1, 2, 3, 4, 5. So again, just for clarification, the entirety of it is a 5-page compendium constituting Exhibit A2. Thank you, Madam Chair.
Thanks. I have one question regarding sort of the impacts to the square footage. And, you know, you didn't cover any interiors. I understand you weren't the initial architect. That was the Middle Wasco team
Yes.
who gave the original testimony. But understandably, because you're cutting out that square footage and from every floor above, there would be impacts. Can you speak to what those designs would be, the impacts, and if those impact certainly the affordable units and whether, you know, if they would still comply with requirements, et cetera?
Yeah, so actually, the previously architectural drawings did not have detailed unit layouts.
Okay.
So they were kind of a rough layout, rough elevations, matching and all that. So we've actually dove into the specifics of it all and have met the same unit count, affordable, everything. So we were able to do that while still cutting out those spaces.
Okay, sorry, somebody had a question?
Yeah, I was just gonna ask them, since now we know, can you tell us where the affordable units are going to be? Are they, you know, where are they relative to the transformers?
They were laid out before the transformers were put in, and if we had to alter it because of that, so it was not based around where those transformers are. I don't have an exhibit that has the units and where they're located, but I can tell you they were certainly located before this came up.
But I guess was their square footage reduced by the fact that you had to cut out part of the building?
No.
Questions? We will get to questions from the public. Yeah, thanks. I just want to offer the board or council the right questions that were raised coming up by the testimony. Okay. That's fine. Yes, we will welcome questions from the public. We just have you come up and just state your name and address, and then feel free to pose your questions.
Charles Bambara,
Just spell your last name.
BAM as in Michael, BARA. It's like Barbara with an M in there instead of an R. I've been a resident for 27 years. Also an engineer for over 50 years.
I'm sorry, Mr. Barbera, can you give us your address, please?
37 Keats, Keats Road in Short Hills.
And your questions.
Okay. If sound from the transformers is a concern, would you not employ sound deadening concrete construction in the cavity where the transformers are? It's very simple to either serrate the wall or put pebbles or something like the sound deadening walls you see on highways. It really doesn't affect the construction at all, but I think that would be a smart thing to do if there's concern over the transformers. It certainly would mitigate that. So I would suggest you do that. Secondly,
I'm sorry, If I may,
Go
Madam
ahead.
Chair, just to be clear, this is for the questions only. The comments will come later when you're sworn in and you can give testimony.
Oh.
Once sworn, that you
All
want to
right.
be sworn so that the
So
testimony
the
counts.
question is, have you considered?
Certainly, and we should give them an opportunity to answer. So
Okay.
Yes, I think we certainly can study any sound deadening. It is a concrete wall, it is clad in brick, and I know there's methods where we can inset the brick and do certain yes, we can absolutely do that.
just so clear, is the applicant, well, before I ask the question, if I may, Madam Chair, the applicant obviously has to comply with NJAC 7:29, the state DEP requirements for sound levels no greater than 50 dBA at night, no greater than 65 dBA during the day at the property lines, as well as our local ordinances, which are consistent therewith. You recognize that, Council, correct?
Yes, I do.
Okay, and is the applicant offering by way of stipulation or anything more in response to Mr. Bambara's question vis-a-vis sound deadening?
We will comply with the state statute, and also, I will also say if there is a sound issue associated with the transformers, provided JCP&L doesn't make us come back again,
No, I don't
we
think
will employ appropriate
I think
sound
this is almost
deadening.
like a no-cost type of thing. It's certainly smart.
And if it's an issue, it's something we will certainly do, provided JCP&L allows it.
So the good faith effort, subject to review and approval of our engineering department, the appropriate personnel in the township with respect to sound deadening materials utilized?
Yes.
Okay, thank you for the stipulation, Council.
Okay. I don't know if it's a question, but just to help the one resident on sound. Sound falls off by the square of the distance from the subject. You might know that. So till I'm sworn in,
Okay,
that might
thank
help
you.
her understand. Thank you.
If I could just mention one more thing. It's typical for these to be site mounted with no enclosure.
These being what, I'm sorry?
Transformers.
Thank you.
So I think already having the enclosure is going to be better. And I'm not a sound engineer by any means, but it will be better. They're usually just site mounted and maybe landscaped in front of them, so.
Thank you. Any other questions for the architect? Okay,
Can I come back? to one?
absolutely.
There were pavers mentioned that were supposed to be in front of the gates. Are those permeable pavers or just regular pavers?
They're what's referred to as grass pavers.
Pavers, okay, great, thank you.
Other questions from the board? Council, are you finished with witnesses? I do want to give the public an opportunity for testimony, but I don't want to get ahead of you.
No, I'm finished with witnesses. I did want to address one thing I noted in the professional reports. The police and the fire marshal report, these are essentially the same reports we got a couple years ago on the initial application. I wanted to note that one thing the board did not approve last go around was the fire apparatus road around the building, because we have a pedestrian walkway there. That's township property and we're not able to do that. So I just wanted to make that clear. That condition remains the same. And that's what was shown on the signed plans that we previously received. But everything else in this report, we've worked post-approval with both the fire marshal and the police department, and of course the pedestrian safety board. We have arrived at a series of pedestrian safety improvements, which the township has approved. We've also undertaken pump tests for the water supply to the building and fire hydrant flow tests. And of course, the building's going to be NFPA 13, as we had previously stipulated.
Madam Chair, may I follow up briefly?
Sure.
With Council on that? So if I understand correctly, with respect to the fire official's memo, you're stipulating to all the items except item number 3 regarding the fire apparatus road, since that was not a prior condition of approval for the reasons stated.
Correct. Item number 2, it appears to be a recitation. Anything where he cites to a statutory requirement, we will comply as applicable. 4, 5 were already stipulated to as part of the initial approval. With regard to 6, we have done the fire hydrant testing, and our engineer has submitted that information, and it's been approved by the fire marshal. So that is already taken care of without any improvements there. 7, 8, 9, things we already agreed to. 10, I believe that was part of the initial approval, but that's no issue. Even if it's new, we will submit the CAD plans, number 11, and of course, 12 and 13, which is not the Knox box, and the numbering of the premises, we will comply with.
Appreciate that clarification. If I may continue, Madam Chair, the police, the Police Department's Traffic Bureau memo of January 3, are you stipulating to the 3 items that are set forth therein?
The way I read this report is he is essentially asking us to comply with the conditions in the prior resolution and the pedestrian safety improvements which are shown on the plans, which we will do.
Okay, thank you for that clarification. And I'm just double checking to see, not to steal any thunder from our engineer. Well, our engineer had no concerns, and our planner, who could certainly speak for himself, if there were any conditions of approval. There might have been a couple of items that potentially could be conditions, I guess, I don't know, unless they've been satisfied in his opinion.
We will have a public testimony. Yeah, I want-
I have a question. May I ask a question?
Yep, let's finish this through and then we have a question.
You're good, Greg?
For clarification, yeah, the testimony has answered the question today.
Good enough, thank you. I appreciate that. Nothing further, Madam Chair.
Okay, thanks. Do you had another question for the
Yes.
architect? Okay.
Well, it's about this report. I'll ask it and then
Okay.
you tell me if it's okay. So,
And I'm sorry, your name again?
Beatrix,
Address.
Beatrix Shear, SHEAR, 101 Oakview Terrace, Short Hills.
Thank you.
So about the fire marshal's report, was there a specific opinion given about any risk from fire pits or grills on the roof? The building is located right next to the Arboretum. As I say, I live right next door. Many, many leaves fall in the fall. And it appears to me that that would create a serious fire hazard. I understand everything would be turned off at 10 p.m. But other than that, there's not necessarily any supervision going on up there. And the fire pits could be on. I don't know if the grills have an open flame or not. And I would like to be assured that the fire marshal or whoever has written this report has considered that danger.
For the applicant's counsel to address.
Council, do you have any?
Sure, and I can put up Mr. Lanzafama to testify briefly, but we do not have any rooftop amenities. That was withdrawn on the
I beg your
final
pardon.
hearing. There's an interior, Mike, would you please go through the plans briefly?
Sure.
Can you just
Referring
pull-
back to exhibit.
Michael, can I request you pull it out a little bit so she can feel it better?
On exhibit A1, the courtyard area where the fire pits would be located are totally surrounded by the building structure. There's nothing up on the upper section of the roof. That was eliminated at the original hearing. So it's only this enclosed area which is surrounded by the building that's elevated. So
The leaves
he
will fall
indicated
there.
that we could not store any propane. There was a condition in his letter, and we will certainly comply with that.
The leaves will fall there. The leaves will fall there. It doesn't have, I don't know how familiar you are.
Okay, we just want to make sure if you're gonna, we will allow testimony. I just want to make sure we're
Okay,
keeping everything at the same.
he hasn't exactly answered the question. And you're saying, so there was no consideration given to any risk from leaves falling on the fire pits or any open fire from the grill?
I don't know if the fire official did that. Your
Okay,
question
that
was,
was
did
my
the fire
question.
official? I can't speak for him.
Well, there was a report, so I thought
Right.
that.
Well, we could read what his comment was regarding the grills, if you
Well,
like.
it's really, the grills, that might be a problem. I'm more worried about those fire pits with the open flame and the leaves falling on.
What he says in item number 4 in his review memo is open flame cooking devices and outdoor fireplaces / pits must only be operated in the designated areas as per the approved construction plans. Open flame cooking devices and fireplaces/pits shall not be operated within 5 feet of combustible construction.
Well, that does it. So that was, I think the answer is that was not considered. The leaves falling on the open flames was not considered. Thank you.
You're welcome.
Other questions? Back to you.
Would you like a brief closing statement on the
Would
amendment?
like to give one?
Okay, I'm just going to say, we appreciate the board's consideration of the application this evening, which is for a very minor amendment, which is necessitated by JCP&L requirements, which unfortunately is outside of the applicant's control and the control of the municipality. Having presented the testimony of our 2 witnesses, I respectfully submit that there is no detriment, no negative impact from the plan modifications, and in fact, the building coverage is being slightly reduced as a result of these modifications. For all these reasons, I ask the board to grant the requested amendment. Thank you for your time.
Singular amendment regarding transformers first.
Yes, ma'am.
Great.
If I may, Madam Chair?
Yes.
And if I may get clarification from council, for the applicant, the sentence in the resolution on page 11 is that is seeking to be amended, amongst other things, is transformers will be located in mechanical rooms and not outside of the building. That's the sentence that gave rise to the modification, including the site plans themselves, which had the transformers interior located as opposed to exterior located, correct?
Yes, that is what the requested amendment is about. I did note in my opening statement that we are very likely not going to need to construct this project in phases, which is a benefit to everybody involved. It will shorten the time frame of construction. So that may be modified depending upon when Summit Medical vacates the premises and terminates their lease, which we expect to happen in the near future.
Okay. And the site plans will be amended accordingly based upon the new proposed revisions. Is that, if this application is granted, correct?
Should the application be approved, we will amend the site plans as necessary to capture the approved amendment.
And you'll stipulate to all of you that the approval would be subject to all the conditions stipulated to already if it's approved, correct?
That's correct, and we've in fact satisfied most of those conditions because the plans have been signed.
With respect, nothing further with respect to the amendment request, Madam Chair. Thank you.
Okay, great. I would like to give the public the opportunity to provide their testimony. So if you would like to provide testimony, we'll have you just come on up and then you can state,
Right now, it's just limited to the amendment.
limited to the amendment on the transformers. We're going to discuss the extension next. Yep, we're just sticking on the transformers now. So if you have any comments or statements you would like to make to the board, come on up. We'll have you sworn in and then you will be able to make your.
Charles Bambara, Bambara, 37 Keats Road in Short Hills.
If you'll please raise your right hand. Do you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you. Further to sound mitigation, and I did ask you, you said you had no plans, but it's, I mean, there are doors and there are sound deadening doors that have, perforated, double wall and sound deadening material. I'd give thought to incorporating sound deadening material. There seems to be a concern. I did want to point out that sound falls off by the square of the distance. So if you're twice the distance away, it's 1/4 the sound. If you're 4 times away, it's 1/8 the sound. So you may or may not know that, but that would help with sound mitigation. But if you can stop the reflection of that sound, that would be the goal. So I would suggest that. That's all I have. Thank you.
Okay. Any discussion concerns? I think you do have something.
I just didn't know, on page 10 of the original resolution, the final sentence of paragraph 7, it says other utilities to be provided to the project include electrical service, gas, cable, and telephone, all of which will be located underground. And I know in theory the service is underground. I don't know if this is part of that will require some sort of technical change the language.
If I may answer, yeah, that's correct. I mean, there might be other items in the resolution, but we're not necessarily, there'll be a new resolution of approval that will be memorializing the board's determination accurately based upon the testimony in the modified site plan and conditions.
Penciling it as-
So we don't, yeah, exactly. We don't have to cross out certain items from here. I just did take note of the one that was the major one. So I thought I'd point that out. Excellent observation. Thank you.
Okay. I think, so we're not on, it's not all said and done. This is only with regards to the transformers, the comments from the professionals, which fire marshal and police specifically, to which the applicant has agreed to stipulate all conditions. Site plans would have to be amended. Do we have a motion to act on,
Except for, I apologize,
sorry.
except for the fire apparatus road, which was.
except for the fire apparatus road as previously, I guess, granted or discussed in the initial application?
And a good faith effort to utilize sound deadening materials for the enclosures, subject to the review and approval of our engineer and other appropriate township
Yes.
officials was, I believe, also stipulated to.
Yes,
And this would be in the context of an amended preliminary and amended final site plan approval. There is no variance relief. It would require a majority of board members for passage.
Okay.
And of course, we'll do a memorializing resolution.
I move to approve.
Second,
Corey Biller,
yes?
Michael Cohen,
Abstain.
Frank Fragamundi,
Abstain.
Sujata Shan,
Yes.
Michael Zion,
Yes.
Gaston Halbert,
Yes.
Beth Zoll.
Yes. Okay, that was regarding the transformers. Now we have a discussion on a one-year time extension.
yes, Madam Chair.
Okay.
What's the date of that expiration? Did you
You
say?
said October 5th.
Would
but
be,
I didn't.
yes, so briefly, and I may-
Resolution
it
was
may-
October 6th.
It was October 6th, I was off by a day.
No.
But I knew.
It's a leap year, so I don't
43.
know. Did you only have 365 days?
Yes. So in New Jersey, as the board is aware, when a board grants preliminary final major site plan approval, those approvals are protected from subsequent changes to the zoning ordinance for a period of 2 years. In this case, the memorializing resolution, which the board adopted October 6, 2021, takes us to October 6, 2023. There's a legal standard for a request for an extension, and we submitted the request under 2 prongs. The statute is NJSA 40:55D-52. I refer to subset A of that test as the flexible balancing test for the board. The standard there is that the board may extend a period of protection on an approval up to 3 times in 1-year increments. The test there is a balancing act. Is the board weighs the public interest in the implementation of any zoning changes which impact the approval. In this case, there are none that we have identified. The developer's interest in extending the period of protection. In this case, we have pursued all of our outside agency approvals and obtained them all, but for the JCP&L transformer location issue, and the circumstances in which the need for the extension arose. The case there is Jordan Developers, NJ Super at 680. Here we have worked diligently to obtain all of the necessary outside agency approvals in connection with the construction of the project. As I noted previously, we have obtained the DEP approvals. We have obtained the Hudson Essex Passaic Soil Conservation District plan certification. The county has issued a letter of no interest. We have met and obtained the internal approvals from various agencies within the municipality, including the Township's Pedestrian Safety Board. We have obtained a TWA permit for sewer for the project. We have also obtained the signed plans from the board's professionals, and we have obtained a demolition permit to remove hydraulic lifts on the property. and otherwise undertaken other demolition of those existing buildings on site. We vigorously and at great length engaged in a year-long negotiation process with JCP&L in an effort to obtain their approvals to locate the transformers inside the building, which is something that we wanted to do, and I think that the board wanted to see as well. Unfortunately, we were not able to do that. So that was the delay in why we were not able to commence construction of the project, although we did commence demolition. So that's our request for the flexible extension under subset A of the statute. Subset D of the statute, which is I call the mandatory extension, states that the board shall grant an extension of final approval if the developer proves to the reasonable satisfaction of the board that the developer was barred directly or indirectly from proceeding with the development because of delays in obtaining legally required approvals from other governmental entities, and that the developer promptly applied for and diligently pursued these approvals. So if the applicant makes that showing, the extension request is one that the board must mandatorily give. So here it's the same fact pattern. We applied for all the necessary approvals to commence construction of the project. We obtained these approvals. We had a year-long negotiation process with JCP&L from which we did not emerge successful, unfortunately. And JCP&L is a quasi-governmental agency. They dictate to us effectively where these transformers go, and their word goes. They will not energize the building absent us locating the transformers in a location which they approve. So for all these reasons, I respectfully request and submit that we have satisfied the extension criteria and ask that the board grant the one-year extension request through October 6th of 2024. Thank you. Happy to answer any questions.
Thanks. Can we ask any questions?
Legal argument, that if you want, respect to the arguments he made, if that helps.
No, it's okay. I'm just clarifying.
You can ask any
confirming
questions, certainly, and members of the public can ask questions, and members of the public, of course, can comment
that-
on the extension as well.
Okay. Did anybody have any questions based on that? Go ahead.
When did you first seek approval from JCP&L?
We obtained a will serve letter in connection with the initial application. The will serve letter essentially is confirmation from the utility that they will provide power to the building, or whatever the utility is, whether it's water or sewer in some instances. Here it's electricity. We then sent and JCP&L really doesn't want to deal with you until you have signed plans from the town. The plans were signed August 1st, 2022. We reached out to JCP&L September of 2022, sent them the plans, paid them whatever the application fee was for the transformer location. We engaged in a series of emails, field meetings, plan reviews with the JCP&L professionals, and were ultimately informed via the letter that I obtained from JCP&L that they would simply not locate the transformers where we had previously proposed them.
So the plans were signed by the township almost a year after the sort of start of the statutory period.
Correct.
Do you have any knowledge as to why the plans weren't signed until a year later?
I'm going to turn that to my engineer. That's a good question.
And since this is a contemporaneous presentation, you remain under oath, and I assume the board will continue to accept you as an expert in the field of civil engineering.
Yes, I acknowledge I'm still under oath. Michael Lanzafama with Casey and Keller again. A number of permits needed to be acquired from the state of New Jersey, specifically a TWA, Treatment Works Approval, which approves your ability to connect to the sanitary sewer system because we're generating more than 8,000 gallons per day, as well as an individual flood hazard permit to be able to construct the building within what's referred to as the riparian zone. Unfortunately, this section of the stream had no prior studies that were acceptable to the state of New Jersey. So we had to perform what's called a HEC-RAS analysis or a flood hazard determination. That took us several months to prepare, back and forth with the DEP. It took us about a full 6 months to secure that permit from the DEP. The TWA took us about another 3 months. The county and soil conservation was about another month. So it took quite a while to secure the outside agency approvals. We had 3 meetings with the Pedestrian Safety Committee to finalize the design of certain traffic safety measures during construction, as well as make the necessary changes to the plan as required by the conditions of approval. As you may recall, there was a detailed study done regarding the arboretum and whether or not birds were going to hit into the building as they migrated. That took a significant amount of time to complete. So until we could get those done, the municipality could not sign off on the plans. JCP&L would not enter into any type of discussions until those plans were signed. You're welcome.
Any other questions regarding the extension from the board? Okay, did the public have questions regarding the extension for Mr. Orth on what he stated? Great, just again, name and address. We're not swearing.
My name is Jeffrey Feld, 11 Alexander Lane, Short Hills, New Jersey. It goes to a statement that was made earlier today about how the project sort of changed.
You're asking a question? Just
It's a big comment because it goes back to whether the application has materially changed.
So
It
just
goes-
if you're gonna do a comment, then we want to have you sworn in to
All right,
give
you want to
testimony.
swear me in or you want me to
Yeah,
ask a question? My hand's raised, give the Bible, whatever you want to do.
Madam Chair, would you like me to swear him in to make that statement
That is
now?
fine, you can make your testimony now.
Okay, do you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and counsel, you have no objection to this gentleman making the public comment prior to the public comment section? Thank you. I just triangulated him for the record, so you're good. Go
Because
ahead.
earlier today, it was disclosed that Summit Medical Group would not be the tenant. And I think of the people that are on the board today that are here, I think only 2 heard the testimony 2 years ago. And it was a very contested, it was by virtual. And the understanding was that Summit Medical would be the tenant. I think today we heard that Summit Medical will not be the tenant for the 10,000 square foot addition for commercial space. That really today, the application is that we're going to have residential and speculative office space. The world has changed since this application is approved. If you read the Wall Street Journal today, a major president of an investment bank says we're about to have a $1 billion meltdown in commercial loans. The question is, has the nature of this application changed material? That's really a question for your attorney maybe to look at tonight, that the application that you thought you were having an extension was basically the same application. The only thing that was going to be changed was the transformer. But when we were here 2 years ago, remember, this was very contested about rooftop decks and things like that. Was this the understanding of the people that voted that Summit Medical was going to be the tenant and they're basically going to continue the operation that they had? Tonight, we heard at the beginning that Summit Medical is not going to go here, that this will be speculative medical office space. And the question is that a material change? And does that affect your analysis, whether to an extension? And the question is, since you approved this, has the town enacted other zoning ordinances? If you did not enact it and they had to come back, such as like a rooftop deck ban, would that be subject to it? Those are the kind of issues we have. But I think something that came out very earlier this morning, during his presentation about the Summit Medical Group, in my opinion, that has to, I think you need as a factual issue and maybe a legal issue, whether the applications are the same because of that change, now that you're really building speculative commercial office space. Thank you.
Thank you. I don't know if you want to make any comments just sort of on precedent on how we approved it. I don't think we had a condition to a specific tenant. I think we had a condition to a use, but I don't know if you can speak to that. I know you did, you weren't the attorney.
No, that's fine. I'm happy to speak to it. I just, there are a couple of things I think we probably should do. Number one, we should give applicants counsel an opportunity to weigh in with respect to his position on behalf of the applicant as to the relevance, materiality, or lack thereof of this change, and what the appropriate standard is, whether a material change to the application is or is not the standard, and if so, whether or not this is a material change, assuming it is relevant to the standard, number one. But also, number two, one of the things I wanted to bring out, and I appreciate this gentleman also pointing it out, was that at the appropriate time, we should hear from our planner I was indicating to him earlier that we need to hear this, which is there was a representation made that there has been no change in our ordinances in the interim, which would have an impact. And I thought it prudent for the board to get confirmation as to whether that was an accurate statement or not from the applicant. So those are two items.
Okay.
Maybe we could deal with the first, if the chair, if you're, with your permission, and we could hear from Mr. Petto as to whether or not his opinion there were any material changes in the ordinances relevant to this application in the 2-year interim since the approval. And I've already sworn him in.
Good evening, members of the board, Madam Chair. Graham Petto here, the board planner this evening. As the aware and the public is well aware, there was a rooftop prohibition ordinance that was passed during the interim period since this application was approved. The ordinance does stipulate that rooftop enclosures must be enclosed by building walls along all sides and constitute an interior courtyard. That is the permitted version of a rooftop amenity space. As configured, I haven't taken a detailed look as we didn't really get a full set of architectural plans to kind of review. So that is something that is kind of a question, but that is one ordinance that may impact this.
And that would impact the zoning overlay as well.
Correct. Yeah, that's a township-wide ordinance.
But as proposed, is there a rooftop or only a courtyard? Would this comply with the ordinance even as amended?
It's a good question. In my initial look at the application, the presentation, it does appear to be an interior courtyard completely surrounded by building walls. It is, there's a street level courtyard. I haven't reviewed the plans in detail, but at initial glance, it does appear that the majority of, there are 4 sides of that open interior courtyard that are bounded by building walls. So
Thank you.
just my initial reaction.
Okay. And any other zoning changes that would impact any of the sort of topics germane to
Not
today's
to my knowledge. no.
So is that the only one, is the courtyard? There's nothing
Nothing on the roof.
on the roof, is that correct? I just want to.
Correct. Yeah. Mhm. Yeah. The ordinance stipulates that rooftop is not permitted, but
Right.
if surrounded by building walls. Correct.
And then maybe, Madam Chair, it's then now appropriate to hear from applicant's counsel with respect to that issue as well, if he wishes, but also in particular the argument that was proposed by the gentleman.
Mr. Feld.
Oh, gentlemen.
So the members of the board that were on, and I actually did the final hearing on this application, so I recall it very specifically. We had stipulated in writing to remove the originally proposed rooftop deck as a condition of approval from the project. Recall we used to have, and this is the basement plan, Mike? That's the rooftop there. We used to have over here, we had proposed a rooftop deck with amenities. That was very controversial, as Mr. Feld noted, and in what was a prudent move, we removed that from the project. We do have the interior courtyard space, that is true, but in my opinion, it is not subject. It is not what the new ordinance was meant to address, and nor does it address technically or as a matter of law.
And as far as the amended approval, does a material change in nature, in your opinion, where does that fall, if anywhere, in the analysis for the board to consider in the context of the extension request? And if it's at all relevant, what is your position with respect to the change vis-a-vis Summit Medical Group not being a tenant occupant, perhaps, prospectively of that 10,000 square feet?
Sure, the use will remain the same. We are not modifying the use at all. We will need a new medical office user for that space. That is not being changed. So from a land use perspective, in my opinion, there is no impact on the approvals that the board previously granted. We did have discussions, certainly, during the initial application on this matter regarding Summit Medical. That was in the context of how we're phasing the construction of the project. It was not from a MLUL use perspective. So I respectfully disagree with Mr. Feld, and I say it's immaterial to the extension request.
And if I may ask the council a question, Madam Chair?
Yes.
Is it your understanding that there is a body of law that arguably prohibits land use boards from zoning based on the identity of the tenant or user as opposed to the use itself.
That's correct. And if you look at the zoning ordinance for this site, it does not speak to specific tenants.
And if the board wishes me to answer whether or not I concur with that legal opinion, I can.
Sure. If I could just ask a follow-up, Graham, this might be for you. It's in the RMF 2. We created a new zoning overlay for this. It would be- Oh, the age. Thank you. And it permits multiple use. It's not just only permitting medical use in those square footage.
Yes.
Okay. And so that's a set, like it's a commercial use.
Correct,
Is
correct.
is compliant with our town.
That's correct.
Okay.
Wait a minute, could you just say that again? So it does,
So it's not that space can only be used by medical, it's that space is, set aside as, I guess, commercial and whatever Milburn Township permits, or I don't want to, if I'm misspeaking, someone please correct me, but I believe it could be multiple different tenants would be suitable for that space.
But I believe, if I may, Madam Chair, and
That's what I
applicant's
wanted-
counsel can address this, I believe there was a stipulation and commitment that it would be medical, just not specifically this particular tenant.
so it can't be any,
So it can't be, okay, that's what I wanted to
Right,
clarify.
okay.
Yeah.
Would that be correct with respect to the stipulation and agreement, Mr. Worth, on behalf of the applicant?
Yes, it's medical office,
It would be
it's a
medical
medical
office.
office use. We can't just put in, neighborhood retail down there. It has to be the same use,
Great, that's what I
consistent with
wanted
the
to
zoning
clarify.
ordinance.
Thank you. Okay, I think if we're done asking questions, then I want to move into the public testimony form. Oh, you want to ask a question? Okay, sorry. Just have you come back up so you can be heard on the mic.
Sorry.
No, it's okay.
So again, Beatrix Shear, 101 Oakview Terrace, and I'd like to ask a question of Mr. Montefano. Now, the courtyard that you're saying is not a rooftop. Can you point that out again?
Certainly. The area and through the center section of the building.
So it is on the roof of the garage, correct?
That is correct.
So in that sense, it is on a roof.
Yeah, but it doesn't
Thank
meet the definition of a
Well-
rooftop amenity as defined in their ordinance.
Well, it is not surrounded by 4 walls, is it? It's surrounded by 3 walls.
Correct.
So it's on a roof, it is not surrounded by 4 walls, correct?
It's also a stipulation in the redevelopment plan that we provide this interior space as amenity space.
But-
It's actually spelled out square footage, what has to be included in it. So we
And
have to adhere to that.
So the fire containing elements, the fire pit, and the 2 of them, and the 4 barbecue grills or whatever they are, that's not stipulated anywhere, correct?
No, that was not.
Thank you.
Just have a follow-up question to what he just said. Again, Jeffrey Feld, there was a reference to a redevelopment plan for this project. I'm unaware of any redevelopment plan being approved by the Township Committee regarding this project. It's never been presented to the Township Committee, so I don't know how he can make a representation as to a redevelopment plan that has not been approved.
Okay, so can you clarify what redevelopment plan you're referencing?
Mr. Lonzafama misspoke. Mr. Feld is correct. There was no redevelopment plan. This was just a rezoning ordinance for this site.
Thank you. Okay, thank you. You have a question?
Jerry Kung, 17 Lee Terrace,
just spell your last name.
Kung. Did I hear correctly earlier that during the prior approval, the location of the COA units was not specified?
I don't recall.
Okay. The reason I'm asking that question, do I have to phrase it in the form of a question?
Yes, please.
Can I ask the board the question, or do I have to ask him the question?
It would have to be
Oh,
of
okay.
the witnesses. It might start off with something like,
Is-
isn't it
is-
correct that?
Okay. Am I reading this plan correctly in seeing that the 2 COA units on this floor plan are, they're not adjacent, but they're directly across the hallway from each other? So on each floor specified, I see 2 COA units, and they're directly across from each other.
Which plans are you looking at?
Architectural plans, you had them up earlier.
So these aren't
all the floor plans. These were just the ones impacted by the that showed the transformer
Are
enclosure.
you picking him up? Does he need the mic?
We have like that.
That's what I'm saying.
He can be heard on.
So I think there's two floor, am I correct in that there are two floors on there that specify COA units?
Yes.
Okay, so the upper left and upper rightmost unit are the only two COA units on that floor shown, is that correct?
Which floor? This one?
Sure, that one's fine.
Yes, there are two currently here. Yes.
And there are no other COA units on that floor?
No.
Okay, and the second floor plan, if you flip the page, is it also the case that there are two COA units on that floor across from each other in the same location as the prior floor?
Yes.
Okay, so those are my only questions. I will have testimony later on. Thank you.
Thank you. If we don't have questions, I think we would be ready to move to the public testimony, but unless anybody else has questions. Okay. So for public testimony, thank you, Mr. Feld, for showing us the way. No, you didn't, Mr. Gambaro did. You will come, you'll raise your hand, you'll be sworn in, then you can provide your testimony with respect to the extension of the timeframe for this application, for, I guess, action to take place.
The extension of the time of protection and vested rights in the preliminary and final approval previously granted.
Thank you. So testimony time now.
Charles Bambara, Bambara, 37 Keats Road, Short Hills.
One more time. Do you swear to God, it's a new section. Do you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
I understand there's a history to this project, and I understand a lot of it cannot be gone back on. I understand that the developer and the engineers all have a significant amount of time and money invested in this. I do want to point out, I'm a new member of the Flood Mitigation Advisory Committee, and I became more aware of the branch of the Rahway River that runs immediately behind this property that begins on Canoe Brook and goes down past the bottom of the high school fields and joins the other branches of the Rahway River. And we are in desperate need of retention, water retention. And this is a prime location for water retention. I understand it's not the time to go back on it, but just be aware that this is a one-time opportunity and it'll be gone. Now, there are construction techniques for incorporating retention in sub-basements. I know that's not part of this plan, but it's something you ought to think about because it's something desperately needed to mitigate flooding in the town. That's all I have to say. Thank you.
We can, let's wait for all and then we'll do it as we discuss. Yeah, I think that's appropriate. So
Jerry Kung, 17 Lee Terrace.
Please raise your right hand. Do you swear to God or affirm testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
It's my understanding, in looking at these plans, I think that there may be some clustering or segregation of the units going on. And I understand that that was an issue with the ANISAS application. With the ANISAS application, I think that we had seen all of the floors for the floor plans for each floor of that building, including the location of each of the COA units. And it was my understanding that there were some issues related to sort of the clustering segregation aspect of the location of those COA units. So I'm just wondering if it makes sense for, sorry, that's a question. It may make sense, in my opinion, it may make sense for the board to ask for more comprehensive building plans and COA location of COA units if you would like to be consistent with that, how that process played out. I'm just a little confused as to how the approval process had gone through the prior time without seeing a location while that was required for any assessment. Thank you.
Name and address one more time,
Yes,
please.
sure. Beatrix W. Shear, 101 Oakview Terrace, Short Hills.
Do you swear to God or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please proceed.
And it's not really factual testimony I'm giving. This is my request, my opinion for the board, that you not approve this extension. So that I did not hear a whole lot of evidence of effort to meet the deadlines. And there was, contrary to what the attorney for the Silverman Group said, there was an ordinance passed, a zoning ordinance passed about rooftop decks that does affect this building. They want to name it something else. They want to talk about the deck that they didn't get to build. They had 2 decks, and this one, this interior one, remains. It is not surrounded by 4 walls, and it is on a roof. And so, because there was not, I did not hear in any event significant evidence of that would justify extending this extension, and there is an ordinance that was passed that would affect it, I would ask that you not extend the approval. Thank you.
Anybody else want to provide testimony? Okay. Applicant's counsel may respond or conclude.
Thank you for the opportunity to be heard. As I recall from the prior approval, and it was actually, I did observe the Andy Says portions of the application. This project was specifically mentioned as one of the ones which work cooperatively with the municipality with regard to the location of the affordable units. The affordable units, and I don't believe we have all the floor plans shown here, do we?
Yeah.
Okay. But the affordable units are distributed throughout the project. They're not clustered. I mean, 2 per floor is very, well distributed, in my opinion. So that just responds to the gentleman who made that comment. Secondly, we've presented you with all of the outside agency approvals. We have pursued the process and the time periods which it took to obtain those approvals, including the fact that we did not approximately a month later, and we then, in an effort to adhere to the original resolution and keep the transformers where we had originally testified, we engaged in a year-long process with JCP&L to effectuate that. We were unsuccessful. We're here tonight for the board's for the extension request. There's also been some discussion with regard to the rooftop ordinance which the township adopted post-approval of this application. We've heard testimony from our engineer, who's also a planner, that ordinance does not apply to this project. Also, the specifications in the ordinance with regard to this site specifically require that courtyard space to be where it is. So we have to adhere to that as a condition of the zoning ordinance that we are specifically subject to, which the township adopted in connection with this application. So for all those reasons, I respectfully submit that we have amply satisfied the criteria for an extension. I ask the board to grant the extension through October of this year. Thank you kindly.
Okay, thank you. I apologize. I do have one final question, and I think it would be prudent for the board to hear the response to this. In looking at the image where it shows where the fire pits are, which is, I believe, to the right of the courtyard as shown on the second floor plan, what I'm trying to understand is where does it exist on the courtyard level, and then what's above the fire pit? It looks like there's building above it, like almost like so that it's in a cave. And if you could confirm or correct if I'm misinterpreting that. Do you understand what I'm saying, Mr. Lanzafanga?
I think so.
Okay. So if you could point to where the fire pits are located,
The
right?
fire pits are located
Essentially
in
to the right
northern
of that red
section-
line?
I'm sorry.
To the right of that red line?
Correct.
Okay.
To the right of the red line, in the northeast quadrant of the of the courtyard. So there were 2 fire pits proposed there. And then we had some grills located at that upper level. There's actually 2 levels to the courtyard. This is an upper level, and then this is the lower level.
And
down to the
effectively,
street
what
level.
floor is that upper level on top of?
It's on top of the parking garage. Remember, the parking garage changes grade as we move through the development.
So in the image on the left, which is called second floor plan,
You can see, so. You can see the courtyard
yes,
is on that level. You can see the parking garage is at that same level.
but where are those pits?
Those pits would be located right along in here by the gym.
No. Maybe further back, perhaps?
There, here is, I'm sorry, you're right. That is actually sitting on top of the gym. The,
Right on top
courtyard
of the
area
second
here,
floor? Is
This
that
area here is actually sitting on top of the gym and the amenity lounge
at the second floor level?
at that second floor level, correct?
Okay.
And that extends back over, so then this extends back over the parking garage.
So from those fire
This
pit
is the
levels, there's
level.
only one additional level of building between that and the roof?
This is the level the courtyard is at. This would be the level that it's above.
Correct.
So
So it's a parking garage.
Okay,
And then the amenity spaces are looking out into the courtyard for a connection between buildings.
from effectively the second floor out.
Yes, technically,
Of
the
what's
first
called.
one, the grade slopes all the way
Yeah,
up,
yeah.
so you're going from basement to second floor, which each floor has some connection to grade.
Okay.
But yes.
Okay, thank you for clarifying that. Sorry, Michael, I know you had a
Yeah,
question.
I have a question too. You said that there were only 2 affordable units per floor, but there are 12 units and there are 4 floors, so
I think in the first phase, which is what was shown.
On the plans that were shown, there,
Okay, so where are the other 4 units?
There's a
It's not 2 per floor, it's gotta be
Yeah.
at 3 per floor, or could be 6 per floor and 2 on the other floors. That's what I'm trying to understand.
no, it's a good question, and the architect's going to respond.
Yeah, so, we don't have the upper floors where the transformers weren't located, we were just bringing the transformer. But once you're above here, the residential completely comes over here. So then there's space on the floor above here, it becomes much larger. So there's one, complete residential floor here, and then there's a partial residential floor, so there's 2 more residential floors above this section right here.
So how many, so can you tell me per floor, how many affordable units there are?
I
on
don't
each
have
floor?
that, but we were matching the affordable requirement that was in the resolution.
And they were at the time distributed and we did, I mean, I
Okay,
can
it
speak
wasn't on
to
the
having
plan
been,
then, right.
exactly, I can speak to having been on the board. I mean, it's not testimony, but I can tell you that was discussed and there was a general distribution of them. I agree with what the observation was that these are vertical, but there were, I think, 8 others distributed elsewhere.
Perfectly appropriate for board members to impart their personal knowledge and knowledge gained from prior hearings to the balance of the members of the public and the applicant. So in fact, it's more important that it be imparted as opposed to just kept in one's head.
Just a question, on closing, you said, you reminded us that you had about a year's worth of negotiations with JCP&L. Approximately how many meetings did you have with JCP&L?
Mr. Lonzafano can respond to that.
We had at least 3 site meetings with the representatives of JCP&L, as well as numerous email exchanges, constant conversations with their engineering staff, a constant back and forth, proposing different alternatives rather than placing the transformers outside the building. We talked about underground vaults within the street, on the property. Nothing we proposed or designed or came up with met JCP&L's requirements.
So can you approximate how many designs or communications there were?
As I said, I remember 3 site meetings. We've had, I know I've had at least 4 email exchanges with their engineering staff. I know the developer did numerous times, as well as the architect, in trying to come up with a solution. I can't give you an exact number, but it was almost a weekly thing.
So it was a weekly thing for 52 weeks?
Yes. They were relentless.
Did JCP&L have published and defined guidelines as to what the requirements were for a transformer in a
Yes.
building of this type?
Yes, they did.
Okay, so it's just, I'm trying to understand why it would take 52 weeks and why you would go through the process of multiple suggestions if there were clearly defined guidelines, which I imagine would have said it has to be located outside within so many feet.
Because we were trying desperately to meet the requirements of the resolution of approval and not have to come back to the board for an amended approval. Simple as that.
Seems like a very long amount of time to be going back and forth.
In hindsight, it was probably unnecessary, but at the time, we were trying to comply with what we represented to the board, what I represented to the board, and trying to give an enclosure. And we know of other utility companies that do allow enclosed transformers. So we felt that JCP&L was being a little unreasonable, but we did not prevail.
Thank you. Okay, thanks. I appreciate the other follow-up questions. So
Madam Chair, would
We can then
a little
have-
guidance be acceptable?
guidance from you before we have our discussion.
Certainly.
Absolutely.
The extension request, as Mr. Worth stated earlier, he did accurately state the alternative standards for an extension under Section 52 of the MLUL, the flexible standard granting the developer the right to seek an extension, bear with me, of 1 to 3 years generally under that flexible standard, which even greater discretion is given to the board for flexibility for the development of large projects. And he also accurately stated the mandatory, if you will, as he calls it, he's not incorrect, language in subsection D of section 52 as an alternative basis, as I understand it. He's saying under either or both, the applicant is entitled to the extension, and the mandatory language has a specific standard because of delays in obtaining legally required extra municipal approvals where delays were beyond the developer's control. And I take it the argument is it was JCP&L that was in control, not the developer. You heard the representation from the applicant that there was no material change in the ordinances which would impact in the interim. You heard our planner testify with respect to same. And I take it the applicant is also arguing the time of submission rule that the ordinance that requires the rezoning, including the inclusion of fire pits on the rooftop, was adopted, or excuse me, was at play and is still at play with respect to this particular application, and that the new change in the ordinance was something that was an amendment after the application was filed and the original preliminary and final approval was already granted and actually technically still remains. I'm sorry, does not still remain. That would have been October 6th of 2023. The applicant is entitled to make a request for an extension, even nunc pro tunc, as we say in Latin. We lawyers sometimes after the fact. retroactive to October 6, 2023 for the 1 year to October 6, 2024. So there are these alternative standards that were referenced. I just wanted the board to understand the applicant's counsel did accurately reflect those alternative standards. If the board finds that the applicant met either one of them, if not both, then the application for an extension would be granted by the board. I think that's, there's no conditions of approval. It's a granting or not. And I think the applicant has spoken to, at least in part, what might happen if it's not granted.
Thank you. Board members, discussion, concerns? I don't know if you had something you said, I'll hold it for later, or if you're able to.
Just a comment, I wanted to discuss the, just mention the retention, Yes, yeah, we did, Ms. Callahan, correct, there are dry wells located on site for stormwater retention, so
Yes.
that was taken into consideration.
Yes, we asked Casey and Keller to include those in the plan to sort of mitigate the flow going into the stream. It wasn't anything prior, this was an almost totally paved lot, and all the runoff went directly to the stream, but we asked them to include the dry wells to help to mitigate that flow.
Thank you.
I have a comment. So it seems that there were clearly defined guidelines from the utility company as to where the transformer could be located. They were publicly accessible. And, it seems that the initial design that they had approved did not take those into account. And it seems like they spent a year trying to work around those guidelines. To me, that seems as if maybe there was a lack of due diligence or poor planning to have designed and sought approval for something that, the utility company wouldn't allow. And therefore, I don't know if it's necessarily the fault of the municipality or the utility company that it took as long as it did, because it seems like they were trying to, do something that was not otherwise permissible to the utility company.
I guess, I think we asked the same question. I think we kind of had the same question, and the response that I heard when I asked it earlier was that they reached out to them, but they just agreed to sort of provide power to the site, and they hadn't got the developer or the architect at the time didn't do that research and that due diligence of saying, okay, we're going to put it on site, where can we put it? And they said, we've seen it, we've done, there's precedent that it can happen enclosed. So that they made the assumption that they could, and that was the flawed.
They made an assumption, they made a flawed assumption, and I don't know that the town should necessarily have to grant an extension because they made a failed assumption.
That's a fair question, sure. We heard, right, either sort of the subset A, the flexible test, or the D, the developer getting approvals, delays. So
What I would say is the developer getting approval delay, they were trying to get approval for something that, had they done the proper due diligence, they would have known they weren't going to get approval for.
presumably, I can't speak. Okay. Comments, thoughts?
I guess this is sort of one of the things, I do acknowledge that working with townships and quasi-governmental entities like JCP&L do take a long time and is slow. What I'm getting sort of caught up on is that they knew at the looming deadline of October 2023, and at some point, and I also appreciate you wanting to comply with the original approvals and have it inside, but at some point you got to say, hey, I see that there's a deadline coming up. Maybe we just sort of cut bait because we knew that there is a deadline. It's not like, so I don't know, it's something I was just thinking about.
And I guess as council, we have the ability to deny, right? That is an option that the boards would have.
Well, a couple of things,
Just trying to follow.
sure. I mean, again, the applicant's counsel correctly stated the two alternative bases for granting. D is mandatory. In other words, the board has no choice if the board, or if the facts demonstrate that the developer was barred or prevented from proceeding because of delays in obtaining legally required extrajudicial municipal approvals beyond their control. But also there's the flexible standard under A, and I don't have this, I can grab this actual standard. In fairness, maybe applicant's counsel can repeat, but that flexible standard is to the extent that one or more board members may be questioning whether it really was beyond the developer's control based upon the dialogue that's already taken place. The flexible standard under 52A, I can grab my book, but you probably have it right in front of you.
Yes.
I'll double check you.
I'm citing to a case and it says, this is the Jordan developers case. There must be a balancing process in which the board weighs the public interest in the implementation of the zoning change, the developer's interest.
You might want to speak louder in the microphone.
Oh, sorry. There must be a balancing process in which the board weighs the public interest in the implementation of the zoning change, the developer's interest in extending protection, and the circumstances in which the need for the extension arose. So as we testified previously, we spent a year obtaining all the necessary outside agency approvals for the plans to be signed, which is a prerequisite for submission to JCP&L to energize the building. So that process with JCP&L didn't start until the fall of last year. So that's when that began. They did issue a will serve letter for the project, which is something that every applicant submits to a board when they come in on an application. It's customary. And that's as far as you're going to get with a major utility company when you apply for approval for a project.
And what is your argument with respect to the circumstances of the case and the implications of denial of an extension and the like? In other words, what's your position vis-a-vis that part of the Jordan balancing test vis-a-vis the board's discretion to grant an extension under subsection A of 52?
Sure. There is we've already heard the testimony from our planner, and the board's planner has confirmed as well, I believe, that there has been no subsequent change to a zoning ordinance which implicates the approvals for this project. Secondly, the developer has a very highly vested interest in extending the approvals here. This is a project which is subject of a Mount Laurel settlement agreement since 2019. The site was rezoned. It was one of the first ones that the municipality rezoned as part of the Mount Laurel process. So there's a constitutional interest in extending these approvals here. Thirdly, the circumstances in which the need for the extension arose occurred as a result of our desire to comply with the testimony we presented to this board and also the condition which was imposed on the application with regard to the transformer location. So we pursued this vigorously in an effort to comply. We were unsuccessful. And this is, of course, a Mount Laurel settlement project. It was one of the first ones in town. It's subject to an agreement, and declining to grant an extension here would potentially be a grave, danger for this project. So for all these reasons, we asked the board to approve the extension.
And if I understood you correctly, it's your argument also that the rezoning ordinance that remains in effect by which this project was approved by this board requires some of the rooftop amenities vis-a-vis.
It requires the
rooftop, but not rooftop in the usual sense, but rooftop of the garage, if you will. Amenities, was that part of your position?
There was a very detailed rezoning ordinance that was implemented for this site, which with very stringent architectural and design requirements, and we comply with all of them. And as I said before, we removed the rooftop deck that was initially proposed when this application first came to a vote before the board.
So other than the rooftop deck, did you foresee any other, because you don't know what you can't predict, but any other potential issues if the extension is not granted?
I don't know. I can't,
and then the other
I'm
thing,
not an elected official. I appreciate those here that are, but I don't know what
and
may
then
happen.
related, because I think we've been trying to get at this information, as far as this quasi roof deck, whatever area, are there walls surrounding at least 3 of the sides, and how high are those walls?
I have to
Yes,
turn back to my professional.
You might want to give him the mic as well.
Rob.
Thank you. So you can see the courtyard is located in this area here. So on this side, because the grade is changing and the building steps up, you have 3 levels of the building on this side and 4 on the other.
And so the space is in that.
Yes, it starts here on the street and enters kind of into this. So you're looking at this here and then it comes in further in there.
So I was obviously wasn't on the board at the time, but can you since you were, can you confirm that the ordinance actually says there has to be fire pits and outdoor grills?
It does not, and they provide, it says there has to be outdoor space for amenities. It doesn't say that there needs to be outdoor fire pits.
Okay, 'cause that was somewhat misleading. I thought that was the way that was
I think
testified.
he did testify that in response to Beatrix's question.
So for clarification on that, then, there needs to be outdoor space.
Yes.
Doesn't necessarily need to be provided inside of that
I think
area.
I think it does have to be located there, but I don't think it specified what.
But it doesn't have to have a fire pit necessarily.
I don't know if they can confirm that, but that was, I guess, do you recall? You were on this application too at the time. I know it needed to be located there. They also wanted to proposed to put amenity space on the rooftop.
It sounds like there's also multiple levels.
Right, the
of
2
amenity
levels. I think
space
those
that
were
are
all part
exposed
of,
outside.
I believe those are part of the required square footage for public amenity
And
space.
then another question I would have is, it seems that there was a suggestion that if we were not to grant the extension, that would put this project in peril. I'd like to know exactly what you guys meant by that. Do you mean that you're going to just abandon the project as opposed to going back and resubmitting?
No, it could. I don't know what action may come in the future. We would like to hold on to the approvals that we had. We worked long and hard for them, and we don't know what may transpire in the future, which is why, and it's very customary for developers to request extensions of approvals for their projects. So that wasn't, we don't know what the future may bring. We are going to proceed with this project. We are going to construct it, assuming the board approved it. Or actually, the board did approve the amended site plan, but the extension of the approval will give us time to submit construction drawings, which will take approximately 60 days to get into the town. And after that, we'll be ready to move forward with construction.
Sorry, more question, more now for our professionals. One is about a year for a project this size. Is that long, average, short for getting everything signed off by the township?
I don't have anything else to really compare it to. This is really the only, I mean,
That's the biggest thing we've done.
yeah, I mean, I don't think it takes a typical residential application. Usually, it takes up to a year for them to get me residential plans. So for something like this, I would expect maybe a year, 2 years would not be. I mean, typically, we never get them within a month. It takes a while.
And
I'm
then
trying to think.
he's represented that it's not uncommon to have extensions. I don't have an experience in this area. Do you have?
And maybe Mr. Petto could speak as well, but if with the chair's permission, if I'm being asked my experience, while it's not a legal answer, I'm certainly happy to give you my experience. Frankly, extensions are generally granted for projects, particularly larger projects. I've been involved on behalf of the boards and the municipalities only. I've been involved in numerous inclusionary projects and 100% affordable projects of this magnitude and even smaller, where there have been at least 1 year extension requests, if not multiple one-year extension requests, which were granted by boards for what it's worth, under, under circumstances not very different from this one. It is, I don't like to use the word routine, so I will not. But I will say that it is regular.
And again, if you're gonna give an opinion, the 1 year to get the town to submit all the approvals, is that?
Well, it's different for every project, I think. As I don't do the developer side, I do the municipal side, but from where I sit, it is different for every project. Certainly, it is not uncommon for permits and outside agency approvals like DEP approvals to take a year or longer, particularly for a project such as this. And you cannot get sign plans until the approvals are in place. So I guess in general, it doesn't seem, in my experience, again, not giving a legal opinion, but just an experience being involved in the administration and the process of projects such as these on the municipal end. Not uncommon for it to take a year or more to get to that point, and not uncommon at all to request extensions of time for the preservation of vested rights of a year or more for projects of this size and nature.
Graham, did you want to add?
Just concur, speak to my, I concur with Mr. Warner's assessment, having, worked on the municipal side only, like Mr. Warner. Typically following large-scale project approvals, if there are conditions associated with that, the applicant is bound to first execute those conditions, begin the design build process, seek the outside approvals, obtain all those prior to submission to even for township review. So, it's not the township that's belaying that process. It's all that other stuff that has to happen for the township submission for those approval process. So, and I just, in my experience as well, I have not seen denial of an extension request. I've seen extension, but I've not personally been a part of a denial of an extension request.
And while not on this type of application, we, as the planning board, have received extension requests as well on a variety of, a handful of applications over the years I've participated, which have been granted. I think we've closed the public comment and question here.
I think it's a matter of order than it is a project question.
It's the discretion of the chair as to
Yes, we will permit
to
it.
take additional question or comment.
My question, Madam Chair, I hate to bring this up, okay? But is it appropriate for a board member to vote on this issue when she's been asleep for half of the testimony? Honest to God. I'm a resident and that's a little insulting.
I'm sorry, I've been sick for 2 weeks.
I understand that, but.
I can address that, Madam Chair.
Thank you.
with your
So
permission.
I wasn't
I
present
just-
for the
I'm
first
sorry,
meeting because
That's okay,
Okay.
board member.
I'm
One-
sitting
Thank you.
here
We have a
observing
question.
that, and this
Thank
is
you
an
for the
important
observation.
vote. This is an important
We're
vote.
gonna, with the chair's permission, we're gonna address the concern you raised. 1, 2, 3, 4, 5. We have 6. Oh, so you moved chairs. Okay. You had a nameplate in front of you that's recused. We do have 1, 2, 3, 4, 5, 6 board members. We need 5 for a quorum. In light of the observation that was made, and I think there was not I think there was a concession that there may have been accuracy to the observation, so there need not be any further said. It would be my legal advice to the board and the board chair that our one board member not vote on this matter, and we do have a sufficient quorum of 6 board members to vote on this matter. That said, I always like to triangulate applicants' counsel, as Mr. Orth knows. Mr. Orth, you have no objection to that?
I didn't observe anything that was complained of. I don't know what to say. I've never heard something like.
She hasn't denied it.
Can
Mr.
I ask if you
Certainly
feel
observed
comfortable
it as well.
voting on the
No, I
application?
didn't bring it up. I just.
She
Yeah.
would like to recuse herself.
She's recused.
That's-
For not for a conflict of interest, but for the circumstances observed and reflected on the record, We have 1, 2, 3, 4, 5, 6, I keep counting just to make sure. We have 6 board members who remain qualified to vote, and thank you for that observation.
And how many affirmative votes do you need?
Majority. My math is 4 out of 6.
All right.
Okay,
Not fun.
thank you. That's great.
Oh, and I will also advise board members for this vote and prospectively, if you're qualified to vote, board members, generally, the obligation is to vote, yay or nay. If there's a reason why you're not qualified or you have a conflict, of course, you shouldn't be voting, you should be recused. But if you are qualified to vote, generally the obligation of the board members to vote yay or nay.
Before going, if I could have.
Go ahead.
One question is maybe for our council. The ramifications of yay or nay on this vote. We were talking about the effects of, if we did say no to the extension, that they would just have to come back and reapply. Is that the only thing, or, and what are they protected from for the next year? If we do grant.
Well, the latter question, what are they protected? Any changes in the zoning ordinances that might implicate or require further approval in the interim period. It's a protection period from ordinance changes is to answer the second question, is what the protection is for, in order for them to then commence construction, which they've already gotten demolition done, but as I understand it, there hasn't been a commencement of construction at least yet. As far as what the applicant may or may not do, if there is a denial of the extension, I'd have to, at least first, rather than speculate, defer to applicant's counsel. The applicant's counsel can address that question.
Well, the board has already approved the application to amend the application. So the amendment has been approved. If there is a subsequent zoning change which impacts the project, then we would have to come back for an approval. However, that said, if the board denies the extension request, I mean, we would have to consider all available legal remedies. And I'll just leave it at that.
Let me ask you, if I may, if the amended approval was granted already, which it was, is there a vested rights protection associated with that amended approval?
I would like to say that there is. That would be a convenient answer for me. I'm not sure what the answer to that is. I'd have to research that. I believe that we have, the application was submitted back in November. We are vested, I would say, with the amendment. I'm not sure, Mr. Warner. I don't know the answer to that.
It's the commencement of construction when they get grandfathered in, or how does that?
Applicant's counsel can address that as well. I wish, sometimes the law is very clear, black and white, yes or no. Sometimes it's a little gray. There's a body of law that speaks to what constitutes vested rights and commencement of construction. It does, I can tell you that there's a case that says soil boring tests are not commencing construction, is demolition permits, demolition of a building, and other grading work and the like. Is that sufficient? It's a gray area, frankly, under the law. And it would be appropriate, not for me to argue whether the applicant does or does not, has not already met that stage. It's for applicant to make that argument.
We have proceeded very far along with this project. We did commence demolition activities. We did receive demolition permits. We have obtained all the other outside agency approvals, but for the actual physical construction permits. So I think Mr. Warner accurately stated, it is a bit of a gray area in terms of when you vest your protection. However, I would argue in the alternative that the commencement of demolition did vest the period of protection. So why did I file the application? Well, I filed the application because it was the prudent thing to do, because it is a gray area, because it is something that applicants and developers always do when they approach that time period of 2 years from the date of the resolution, for the avoidance of doubt. So there's been a tremendous investment by the developer in this project, and there has been on the part of the board, as well as all the board's professionals over the period of years in how we got to here today. So certainly we have all vested ourselves in seeing this project get under construction, and we're very eager to start that process. Thank you.
Thank you. Yeah, I mean, the JCPL notwithstanding, they did have to go through, multiple government and quasi-governmental approvals, permitting, we heard, it wasn't that they just said, oh, we'll just reach out to JCPL, we'll wait, and they went back and forth. They did all the other flood and whatnot tests. So I feel like were they making good faith efforts to advance the getting to construction? I feel that you can argue they did take steps. They weren't just waiting. Yes, I don't know that we heard, you submitted plans, you said September, maybe last year after you received the sign plans. I don't know when you first heard back from them saying no, was it within a week or 2 weeks or a month or 2 months? And then, this year-long back and forth. And then sort of the question that I think was come up to the board is, at what point do you say, okay, we gotta rework this so we can meet the deadline or whatever it is? And I understand you're trying to get there, but I think that's what's raising maybe some questions. Mr. Warner said it didn't say it's routine, but Graham and Steve characterized that it is typical for boards to grant extensions, so it doesn't seem so out of left field. I know we have as a board done it, so I'm inclined to think it's a practice that exists, that's out there. There's multiple subsections dedicated to it. It's not an irregularity for a developer to require additional time to get all their collective ducks in a row.
And on the topic of vesting occurs obviously at some point, but it's whether it's shovel in the ground or testing or something, there's some action by the developer that sort of initiates this vesting period, correct?
That's correct.
So in theory, I was talking about cutting bait. In theory, if a developer wanted to try to ensure vesting or help ensure vesting, they could cut bait earlier, seek this amendment earlier, and then put a shovel in the ground to try to protect their vesting instead of. So what I'm saying is one of their arguments is that what they saw from JCP&L was in the interest of complying. So had they, if you're going to carry that forward, assuming that they're taking their word for it, if they weren't as interested in complying and they were more interested in protecting what would arguably their right and best in their right of protection, they could have, like as I said earlier, cut bait earlier, sought the recourse that they're seeking currently now earlier, and then put a shovel in the ground to, in theory, protect their interests. So okay.
And they didn't do that though.
Correct.
Right.
Yeah. So we're here and they're asking.
Right, so I think deadlines exist for a reason. I think there's something to be said for that. It's not absolute that we have to grant this extension.
No, but I think it goes both ways actually, is that if we take their word at it, and I think getting the transformers in the building would have been better for the community. So if they were arguably fighting for compliance with what was required originally to avoid coming here, they could have stopped that and said, like, I don't care, we'll put it outside and seek our planning board's approval, 6 months ago, so they can put a shovel in the ground and protect their rights in theory sooner, is one way you can also look at it.
I don't think that the applicant has not made a good faith effort to comply. That's just my view.
I'm sorry, I think that was a double negative. You don't think they have not, so just for clarity, you think they have made a good faith?
Faith effort to comply,
Okay.
yes.
Usually we attorneys use the double negative. So, but
Okay, so that said, there was just 6 of us, so we could potentially take a motion and vote and go from there. Okay,
What's the standard?
sorry?
When you do a motion, make a motion whether it's under A or D.
you're,
Thank you.
yeah, the gentleman from the public, I said, gentleman again, they requested it. It's not required the board do that, but certainly the board has the discretion whether it wishes to say under sub A, sub D, or both, or neither. Certainly the board has
Oh, the crux of the.
discretion to do that.
I will move to grant the extension as requested by the applicant. I think by both the flexible test and the subset D as well. I felt there was justification, so that's my motion. Is there a second? To grant the extension. Okay.
Or is there
Is
an
there a
alternate
different
motion to either grant or deny? An alternate motion to grant could be on one or the other of the two bases as opposed to both bases. But we don't want to, we can't split up the vote too much because it ultimately has to be one vote to see how many out of 6 is in favor of the motion.
Would it be fair to make a motion? Well, I also think we need a time frame in it, quite frankly.
I think the request was 1 year.
Oh, it was.
Yeah.
Okay, so-
I assumed, I'm sorry, I assumed the motion was for 1 year.
It was applied. Does anybody want to make a motion?
I move to make a motion to approve under
Flexible test.
the flexible test or not D.
And also for 1 year?
The first 6 months, but the application was a year, so.
And
Did
the
it
1
say
year,
for in 1
the
year
1 year would be
increments?
non-pro-tunc, so it would be
October 6th.
Oh, okay.
October, it would be until October 6th, so
That's all I had.
I don't even know, yeah, it'd be about a 9-month, I guess, from here on in. So is it,
Yeah. So I would make a motion to approve the year based on the flexible but not the required.
and the 1 year ending October 6th, 2024. Okay, we have the motion. Is there a second for that motion?
Second.
So your motion you withdrew.
I had to.
Okay.
Well,
Got it. Corey Miller,
Yes.
Michael Cohen,
No,
Frank Segamondi,
No.
Michael Zion,
yes.
Gaston Halbert,
Yes.
Bethel.
yes.
Okay, 4-2, the motion passes. I'm sorry, I took your, Eileen, you
That's
said.
okay. You go right ahead.
Just thank you for everyone's time tonight. We appreciate your attention and consideration of the application this evening. Thank you very
We
much.
hope you can act within your year.
We're going to be moving very quickly. I think we've gotten a very clear message from the board. Thank you.
Thanks. We're gonna take a 2-minute break and call back the members to recess, and then we will continue with our Okay, we're back. Okay, we're back and just announcing for the record, Deborah, David, and Allison rejoined us. Welcome back. We're going to move on to our business items, but because it is already almost 10 p.m., we are going to propose to adjust the agenda for this evening. Graham, if you could stand up, you were going to speak, we're going to speak probably for a while, so we invite you as our planner to approach the mic. But our discussion of the open space element of the master plan, if you can speak to the discussion and also the items that are available to the board and the public.
Sure. So, good evening, everybody. Graham Petto, serving here as Township/Board Planner. Was excited to share the open space plan with you all this evening, but in the interest of the late hour and trying to make sure that the public has full access to this, I suggested to the chair that we perhaps consider carrying this introductory presentation to the February 7th meeting of the board. I believe at this point we have no other matter scheduled that evening, so it would be the only item on the agenda and allow for better transparency and presentation. I have provided my digital presentation to the board secretary, so that will be posted on the township website tomorrow, so everybody can even take a look at all my slides. But I was going to present this evening in advance of the meeting on February 7th. And again, that is just going to be an introduction of the plan element. That is not the statutorily required public hearing. That will then be scheduled following the introductory presentation. I do just want to again thank the members of this board, particularly our subcommittee members, Ms. Nevis and Mr. Halper, for their work, and also to the 1,300 residents that participate in our public outreach process. So I'm looking forward to sharing the results and talking through the plan. But that's my recommendation that we.
Thank you, and we can just confirm that on February 7th, when this would get carried to, it would be the first item of business, so that if people are interested in coming, it would happen at the beginning, even regardless if there's other items to discuss. We could do that.
Like
Yeah,
first,
I would, yeah.
First.
Yep, I would like that.
Okay.
Because, especially because we were intending to have it and we're gonna push it. Okay.
Yes.
So thank you, Graham.
Sure.
Okay, that brings us to, does that need to be renoticed? Or
We
is
noticed
this?
it.
It's not a notice.
Okay.
Yeah, it's not the formal public hearing. So just, I guess,
Gotcha.
in the interest, it's just introduction. The formal hearing will be noticed in due course.
That is correct.
Okay, we have two ordinances to be discussed tonight. The first is 2657-24. This is on the prohibited uses, DRZ 301 and DRZ 604. And Mr. Miller has
Just
a comment.
My only comment is that to the extent that we can, I think I only received, and I think the rest of us only received our professional reports this morning before this, and had a particularly busy day, so tried to delve into it, but I just, if we are permitted to, I'd like to push the discussion of this to another meeting so that we have more time to review and think about our professional reports before voting on something like this. So I just wanted to bring that up before we started substantively talking about it.
The TC is scheduled to take it up at the next meeting, and I don't believe you have a planning board meeting before then, so it really should be done.
That's right, but we do have 35 days to act on it, like sort of technically. So we just received it effective today or effective from yesterday?
Introduction was last evening, so I think the formal transmission was today. Correct.
Right, so I recognize you are hoping to act on it in the sort of 2-week timeframe, but in sort of the due diligence of allowing us the opportunity to review it, to have our planners report, I understand the concern. That's what Mr. Miller's raising.
I mean, I'm certainly ready to go right now.
Yeah, I am too.
I read everything and
It's very straightforward.
Well, it is.
Madam Chair,
Can you turn your mic, please, just to make sure we're getting picked up? No, I just want to make sure that's
There we
for the
go.
record. Everybody
There we
is
go.
here.
Madam Chair, if the chair wishes, I can briefly speak to that. I mean, certainly it's ultimately up to the board to decide whether they proceed or not. In my experience, first of all, to make clear for everyone, there's really only one issue here with respect to each ordinance, and that is whether the ordinance is inconsistent with our master plan or whether it is not inconsistent with the master plan. I know that's one of those double negatives, but it's actually the way the statute reads. So we have to use that double negative, not inconsistent. That really is the only issue for the board to consider. I certainly recognize that the board only had a certain amount of time to review the memo, but we do have Mr. Petto here it's not testimony, it's not a public hearing. The public hearing happens after the second reading of the ordinance before adoption at the governing body level, so members of the public get a public hearing at that point in time. It's not uncommon to analyze to a question that was asked in the last matter for master plan consistency reviews to not have too much of a lead time, given that the governing body introduces and there is only a certain period of time within which to proceed thereafter, and it is a fairly isolated issue, consistent or not inconsistent. Now, all that said, the board decides whether the board has enough time or not, and it could decide that now, or it could hear Mr. Petto briefly and decide whether it feels comfortable or not to proceed after hearing that. It's up to the board.
Sure, do you want to take a vote if we feel ready to?
It would be a straw poll because no
Yeah,
vote.
just like- Okay,
Yes.
so do we, I guess, hands if we feel ready to proceed and hear the.
Maybe it makes sense to have Mr. Petto make his presentation first, and we'll see, see if we feel that more time is needed.
Can we ask if people feel comfortable proceeding? Yeah, I think. Do we want to have Graham speak to us and reflect?
Sure.
We want to advance it, or do we feel that it's? Okay, great.
All right, good evening, everyone. So we do have two ordinances that were introduced last evening at the Township Committee that are here for referral for consistency determination by the Planning Board. This consistency determination is pursuant to Section 40:55D-64. The first ordinance that I'll speak to is 2657-24. This is an ordinance to amend the prohibited uses section of the DRZ here in the township. Specifically, DRZ Section 604 provides a list of uses that are prohibited throughout the township. Presently within the ordinance, this list currently contains only cannabis-oriented uses and all other uses not expressly permitted in the ordinance as the full set of prohibited uses within the township. While case law holds that these are not expressly permitted or considered prohibited, relying on this clause leads the township development regulations and zoning ordinance and also municipal staff up to kind of interpretation on some level of these things. Susceptible to interpretation and challenge, I say. To resolve this potential issue, this ordinance before you now explicitly lists some further issues that would be prohibited within the township. Those added uses include pawn shops, rooming and boarding houses, sexually oriented businesses, slaughterhouses, smoke shops, tattoo parlors, including body piercing establishments, and retail wholesale of weapons or firearms, including shooting ranges. In addition to that, just for the benefit of the board, we've also the ordinance also creates corresponding definitions for these terms. So those are now defined uses as well, creates a little bit more transparency for staff administering the zoning ordinance. Next, I'll go through and talk about the relationship of the proposed ordinance with the master plan. So the above ordinance advances the following objectives and recommendations of the master plan reexamination. One, protect the character of established residential neighborhoods, encourage land use and development at an appropriate scale and density. This is objective 1.01 of the master plan on page 43. With the exception of an existing smoke shop lounge on Upper Milburn Avenue, these uses do not presently exist in broad scale across the township, and the Township Committee seeks to protect the township's existing character from uses considered to be deleterious and undesirable. Two, promote clear, user-friendly, and transparent application review and public hearing processes for development proposals and applications so as to ensure an effective and well-publicized mechanism for residents to report on quality of life issues and code violations. The additional this is page M1 of the master plan is the statement. The additional prohibited uses will explicitly stipulate various uses that are commonly prohibited in suburban New Jersey communities and that do not presently exist within the township. Formal inclusion of these uses on the prohibited list within the DRC will eliminate confusion and facilitate smoother land use administration for staff. So those were the two master plan consistency areas that we identified as part of our review.
Sorry, and maybe I didn't see it because again, I didn't have a ton of time to review this, but you said that there were definitions provided of.
Yes, in section 1 of the ordinance, the text of the ordinance, these terms are defined, such as rooming house, and these are now defined terms within the ordinance.
So, but those terms like smoke shop, rooming house, tattoo parlors, are there defined terms for that, or those are the defined terms?
There are defined terms for that.
It was in the.
Well, again, that's one of the issues I had with having this, is that I skimmed it because my calendar today was packed. Okay, that was just my only first question.
Any other questions? Yes.
So how common are these prohibited uses as defined in other towns?
Most other communities do include this prohibited list. Is actually, we've looked at other communities where we do land use administration, and this is examples of uses that we find in other community ordinances. So this is very common.
Okay, so Milburn doesn't have this already, as opposed to other towns where this has been clearly defined and delineated.
Correct.
Okay, all right.
Yeah. So, and it's important, the distinction is that, while Milburn does prohibit these uses by that catch-all statement, which says all uses not expressly permitted are prohibited, that does lead to some kind of confusion, in administration. So the intent here is to kind of clarify that confusion.
The things that are prohibited currently, is there a list of things that are permitted currently?
Yes, within the ordinance. Each zone district expressly states what is permitted in those use categories.
So here's, I guess we're going to talk about the substance of it, of the several minutes I got to review this. Here's where my concerns were with regard to being inconsistent with the master plan. In the 2018 master plan reexamination, it discusses the negative impact that e-commerce is having on sort of downtowns like Milburn and other places, and talks about the need to attract experiential businesses, including personal services and establishments. And some of these preclusions seem to limit Milburn's ability to accomplish this goal of attracting more service-oriented businesses. Now, we could have more barbershops and nail salons downtown. God knows we don't have 75 of those in a 2-mile square. The other issue I have with regard to the master plan is that the survey, that the 2018 reexamination, over and over again re-emphasized, or respondents re-emphasized the need for diversity of retail. And my concern is that in times are changing, values are changing, and who determines that a smoke shop or tattoo parlor, body piercing, some of these things are deleterious and undesirable? Because, just my own unscientific observation is that from when I was growing up to now, tattoos are a lot more common. And people are not like in biker gangs and things that used to be associated with it. Same things with body piercings. What is it to say that is deleterious and undesirable? Same things with smoke shops. And again, I didn't see the definition of smoke shops. So I'm not sure exactly how that's defined, but we already do have a cigar shop. And other than that was brought to our attention once because of a change, the next door neighbor, but nobody else has seemed to have an issue with that. So that's my concern, is that it is inconsistent with the master plan, at least revisioning 2018, at least from these two provisions. But again, I didn't have a ton of time to go through the whole thing.
I would disagree with that. So these types of establishments are not currently permitted. Therefore, they would fall under that catch-all. So they're not currently permitted, correct? And this would just bring clarity so that we don't have officials in town hall having to make a judgment call as to whether this is or is not permitted. And these are consistent with what other towns have in terms of prohibitions on certain types of businesses. And while I understand your desire to have diversity of businesses, I don't think these types of establishments are reflective of the character of our town. And I don't think that this is the type of thing that we necessarily want to have out there, without clarity. We should take a position on it.
So it would help a lot to when we say that this is currently not permitted, Could you explain a little bit further about why it's not permitted?
Well, so I think Mr. Saccomandi's point also kind of opens the door to some of the interpretation issues that staff have administering some of these ordinances. I think one of the things highlighting a smoke shop as a use, under the current ordinance and in the absence of it stipulated as a prohibited use, when a prospective zoning person comes in, and having done this myself on the municipal side as a person in the zoning office, they say, I want to open a shop that's going to sell cigars and, I have cash and we're selling things. That's a retail transaction. So at first blush, that's retail. That's retail sales. So retail's permitted within the zone. So we permit retail sales. So that's where some of this definitional gaps start to occur. Same thing with tattoo establishments. Personal service definitions. We have a personal service definition here within the township is an establishment that renders a service to a person, a haircut, get your nails done. Those are personal service establishments. Tattooing could be looked at as perhaps being a personal service establishment in the absence of a prohibition on that use or a further definition defining where that use may be permitted. So this ordinance kind of solves some of that administrative question and provides a little bit more clarity in that process. I hope that kind of answers the question a little bit to create some definitional
But it
clarity.
also, to me, it gives a value judgment on, so it's not, I disagree with you in the sense that it's already prohibited. I don't think it's already prohibited. I think it would be prohibited by this. It might be, somebody might, no, actually, I can't think of a way that it's prohibited currently. I think it's adding a prohibition that doesn't exist currently based on certain value assumptions that limit, that ultimately limits this town's ability to, increase retail opportunities, tax revenues and things like that. If it's really not something that's desirable in the community, it would fail as a business within 6 months to a year and be out of here. So there are certain things that I think are more obvious than others, like sex shops and things like that. But again, that's even that, in fairness, is my value assumption. So so I think at least with respect to some of these prohibitions, some of these things to me are less obvious than others to be deleterious and undesirable, and they seem inconsistent with the 2018 responses to the re-examining as well as the sort of the text of it.
By this definition, like if a jewelry store wanted to offer piercing, that would not be permitted too.
Correct.
And that would be us saying that we think this is deleterious activity. Okay.
As presently defined.
Right, and that's a personal issue, and I would say I disagree with that assessment. I don't think that is consistent with the master plan from a personal evaluation perspective. Sorry?
Then vote that way, I suppose.
Yeah, no, I'm sharing, because I understand that as part of the TC, you wear a couple frames, I just want to give you feedback, I guess, from a personal perspective. And same, I guess, tattooing would just not permitted at all. It's not like it's a primary use or whatever, just it's not a permitted service in the town by this proposed ordinance.
Correct.
Okay.
Are these restrictions common in other towns like ours?
There are certain communities that do, prohibit these. There are some communities that have created permissions for these uses. So, it kind of depends on the community. So, but this is a list of prohibited uses that we see in other similar communities in the area.
Could these activities happen at the mall in Westford Hills then, for instance?
It's a good question, I'm sure. No, I mean, if it's a
wouldn't be
prohibition,
permitted
it would not be, I thought the question was, do those currently happen?
No, could they?
That. No, if it's as characterized here, this is prohibited uses throughout the township.
Yeah.
Sorry, who came up with that, why were these particularly identified? Was there reasoning as to why the things that are in this ordinance?
This was wearing my, because I do wear two hats. One is board planner, one is township planner. As township planner, there was a request from the TC, from administration to prepare an ordinance. We took a look at similar communities that have a list of prohibited uses, and this was the list that we put together. This was advanced based on that initial review. So,
What about, so smoke shop, for instance, we already have one in town. So if it's existing, is grandfathered in or it's under?
Correct, yes.
That's correct.
And that was called out.
And if,
Yeah.
and if
Yes.
something is grandfathered in, that means that in the event there were to be an intensification or an expansion of that use, they would still require a D2, it's called, but D variance relief from the zoning board of adjustment. When you're grandfathered for what you got, so to speak, but not more than what you got.
And it's, as the case with anything, just because we have these, I guess, prohibitions or restrictions in place, if a vendor wanted to come and locate in town and provide a service that wasn't, permitted, they would have to come before a board and seek a variance, which is.
Yes, a D1
Which
use
is exactly
variance.
sort of the types of things I recall, both in the master plan, we talked about making it easier for businesses to to come and locate in town. So this would be potentially, if it were some of those businesses, which we're saying we don't, want effectively, they could come to a board and seek variance relief, but that
Sure.
would be kind of the opposite of inviting new business into town from that perspective.
And just for clarification, that board, of course, would be the other board, the zoning
Yes,
board of
yes.
adjustment, because it would require D variance.
D variance.
Right, you should also keep in mind, is it better to have them come ask for permission or to have no recourse once one of these comes in, and we may find that to be undesirable?
I think you've made a good point. If it's not desirable and the community is not, supportive of it, then the business may not succeed.
And I think if they're more likely to just go to another town than seek permission. And we may have just, had a business sit open for another 6 months, a year, or whatever, that we're losing tax revenue on.
But wouldn't people from other towns come here to get the service? It's not necessarily the people in Short Hills. I can't see the people in Short Hills going for tattoos. But people could come into Short Hills to get a tattoo if they established it.
But potentially, sure, but
So
when
the
they come
business
in,
could be
they might also
successful. So
stop
I
at the
don't,
deli.
yeah, I
to
don't
get
think that, I
food.
don't think the market argument necessarily holds.
It potentially changes the character of the town as well. And we shouldn't be short-sighted on a few dollars of taxes, which is questionable on whether we make any real money anyway.
But I mean, we have a smoke shop now, and has that brought crime to the town?
Well, I mean, I think when you think of a typical smoke shop nowadays, they're, like vape shops are selling paraphernalia and other things. What we have in town now is I would say, a upscale cigar bar, right? Which I think is something that.
Well, again, I didn't have a chance to look at the definition. That's one of the reasons I wanted to push this to another day, so I have more time to look into this. Because if the definition of a smoke shop is something more elegant and high scale, then that, is potentially different, but I haven't had the opportunity to really review this yet.
Can you read the definition of smoke shop?
Sure, certainly. Smoke shop shall mean any premises dedicated as a principal business to display, sale, distribution, delivery, offering, furnishing, or marketing of tobacco, tobacco products, electronic smoking devices, or tobacco paraphernalia, including providing an area for smoking tobacco products, but excluding any grocery store, supermarket, convenience store, or similar retail use that sells tobacco products, shall not be included within the definition of a smoke shop. An area for smoking shall mean the burning of, inhaling from, exhaling the smoke from, or the possession of a lighted cigar, cigarette pipe, or any other matter of substance which contains tobacco, or any other matter that can be smoked, or the inhaling or exhaling of smoke or vapor from an electronic device.
So that would include like a vape shop.
And Tonino itself wouldn't be permitted.
However, they would be grandfathered in this case.
But you can still have a retail shop selling bongs and other stuff, I suppose.
No, tobacco products or,
Well, they can't sell cannabis.
oh yeah, there's a separate, and cannabis is existing. That's an existing prohibition.
I have a question.
Sure.
Is there any kind of scale where it's A retail, B retail, C retail, in other words, a scale of what's considered prime retail versus, say D, where it's, and is that based on dollar amount or is there a scale out there?
I'm not sure, from a planning and zoning perspective, there is not. We have a retail definition, but it doesn't define classes of retail or anything.
That's
to
what
that.
I was looking for.
No.
Thank you.
Could you shed a little more light on J?
J. All uses not expressly permitted in this ordinance are prohibited. Yeah, so that's a catch-all statement that applies to the ordinance in its entirety, that, absent any express permission, it's not permitted.
Isn't that what we have now?
That is what you have now, correct.
We just moved it down.
We just moved it
Yeah,
down.
From B to J.
It moved from B to J.
So in essence, even if we didn't put all the others in, it would come before us and we could make that call. J gives us that permission.
There's judgment.
It would
Yeah,
go
that's
the
the problem. That's why this is.
Right, so there is a level of administrative judgment that has to happen by staff to determine whether it fits another defined category within the ordinance. We have retail and retail service. There are other definitions that are very broad, which allow for great flexibility in reviewing potential uses. But this list creates a subset of expressly prohibited uses that are more defined, essentially. That's what this is doing. And just to clarify your last comment, that anything that is, that's seeking to locate within the town that's not permitted would go to the zoning board of adjustment, not this body, because they would require a D variance relief.
And Michael, it's not even just the tax revenue, it's, people come in, if we had another cigar lounge or something like that, they might order pizza from there, or to go to eat their food, they might, go, Lobster Shack, whatever it is. Tattoo parlors, I can even think of, you go into Original Sharp, the barber thing, all of their barbers, who are pretty nice guys, are tatted up from their toe to their top of their head. Those guys come in, they can get more tats, eat food, stuff like that. I just think it becomes very dangerous, especially when our town has told us that they want that the town is changing and they want to utilize different services, to start legislating against certain businesses and sort of tying our hands on certain things. I think times are changing, so assumptions about what, bikers coming in and getting tattoos and piercing and stuff, I don't know is necessarily.
Was there any public input into these decisions, like these classifications?
No.
If I may, Madam Chair, just.
I mean, on the part of the
Yeah, okay.
recommendation. of
Well,
it.
no, I was just gonna add something when he's done.
Oh, okay.
Not to this point, no.
That will happen later.
That the public hearing is scheduled.
Okay.
That's-
Yeah, that was one of the things.
That's what I got.
That's provided for the process of a public
I
hearing, of
just didn't know if
course.
like the brainstorming for the list came from some brain. Yeah.
Also, I suspect it's difficult, perhaps even impossible, to segregate the master plan consistency or inconsistency with sort of the policy determinations that, of course, are the jurisdiction of the governing body and not the board. I think everybody kind of pointed out how there's some overlap, if you will, because there were some objectives that were referenced by one of our board members, reflecting a opinion that it may be inconsistent with some, at least, provisions. And of course, there are provisions, two at a minimum, in which our planner tells us it is consistent. For the benefit of the board and the members of the public, I don't know how much benefit it is, frankly, but to help you with the standard is not pure consistency or perfect consistency when the board makes its determination. That's why, in part, they use the term not inconsistent. Substantial consistency is, under the Riggs case and others, the standard. So I don't know how, the extent to which, if at all, that helps. But sort of, I guess another way of saying it is, what did they used to say? Almost doesn't count, except in horseshoes and hand grenades when we were kids, maybe. But, well, almost counts, sort of, almost consistent or substantially consistent is sufficient for a finding that an ordinance is not inconsistent. Again, that's a determination for the board to make, if that helps. Also, if it helps, as the board may know, whatever the board determines, for example, if the board does, and this is for all master plan consistency reviews, if the board determines that the ordinance is inconsistent, the next process is for the governing body to decide whether to abide by that finding or with an effective majority, i.e. a majority of all the governing body members, and what we call a reasons resolution, make a determination that notwithstanding the planning board's finding of inconsistency, the governing body decides for various reasons stated in the resolution to nevertheless proceed with the adoption of the ordinance post-public hearing. So I just want to make sure everybody, including our new board members, know exactly what the standard is and also what are the ramifications of a vote one way or the other.
And just some background, so this did start coming out of public comment. One of the speakers at public comment raised a request for the township committee to consider a ban on gun shops. And so following upon that, the township committee asked Graham to just take a look at what other towns have and to come up, and that's how this list was generated. So it did actually start from the public.
Thank you.
I have a question. So we've heard two different takes on whether it's consistent or not. How does that play into deciding whether it's substantially consistent?
It's like a judgment call, right? I don't know.
I know you got it. I mean, you have a planner who may or may not opine one way or the other. You have, that's the bailiwick of the board members. That's your discretion to make that determination based on what's provided to you by the planner with the legal guidance and your own questions, answers, and deliberations.
Yeah, I do feel that restricting, gun shooting ranges might be appropriate for downtown Melbourne, absolutely. But I don't know that I agree with all of the proposed permitted uses. I think some of them miss. It is my personal opinion. But I appreciate that. Thank you for the context of, kind of the origin of it. I think that's helpful.
So I guess I'll make a motion that that this ordinance is not inconsistent with the master plan.
I second it.
Okay, and if I may, Madam Chair. I'm sorry.
This is a double negative. This is, now it's allowed.
That's allowed.
It's okay when he does it.
Because that's what the statute says.
And if I may, we did, as a best practices, in my opinion, we do draft a resolution. It's pretty bare bones, one page. When you get a lawyer to draft a resolution, that's one page. As you know, that's pretty bare bones. This draft resolution provides for a finding that the ordinance is not inconsistent, the double negative. That's not meant to be anything other than to sort of a template for the board to start with, and you decide ultimately whether the word "not" stays there in the resolution or not. So we do provide that. So if the board is going to render a determination one way or the other, you can go right to a memorializing resolution in one vote this evening. So that is that one-page template that was distributed earlier. I just gave you the synopsis of it.
So there's a motion on the table from Michael and a second from Allison.
That it is not inconsistent with the master plan. Cory Biller.
Question.
Whoa.
We can have more, I'm sorry. Go back to substantial. If it's 50-50, that's not substantial, then it is inconsistent, or it is not inconsistent. This is like.
That's like I said, not everything in the law is black and white, 100, a yes or a no, 100%. The case law is not inconsistent, substantial consistency. I think it's fair to assume that if it's a sort of a 50-50 Well, I don't want to say what's fair to assume. You have to decide what substantial consistency is and what not inconsistent means. It's really for the board to make that determination. The cases don't go so specific to say, 51% is here and 49% is here and 73% is there. It's not that discrete and quantifiable.
And it's totally based upon the master plan and not about personal preferences.
It's totally based on the master plan. Is it consistent with the master plan? Excuse me, is it not inconsistent with the master plan, or is it inconsistent with the master?
For the record, I have no tattoos and I've never smoked. Don't have a gun either.
We know of.
So, so it's to vote not inconsistent, we would say yes, it's not inconsistent. To vote that it is inconsistent, we would say no.
Correct.
On this motion and second and roll call vote that's about to happen, correct?
Corey Biller,
No.
Allison Canfield.
Yeah.
Michael Cohen.
Yes.
Deborah Nevis,
No.
Frank Sagamundi,
Yes.
Sujatha Shan. David Cosgrove,
Yes.
Oh, and we only have 9 voters, even though we have 10 board members here, someone's an alternate.
Gaston Halbert.
Say no.
Betzel.
No,
Does not pass.
it does not pass, which means the report or the.
Well, we
the
know,
letter- Oh,
I'm sorry, Madam Chair, I
Go ahead,
apologize
you
for
can-
interrupting, but when a motion doesn't pass,
You have to know.
we
You
have
have
to
to
go
do it
to
in
the
reverse.
alternative motion,
Understood,
because we do not have
you.
anything that passed yet.
thank you.
And I'm sorry, that was 4 to 6, did I get?
It would have been.
I'm sorry, it would be
nine.
4 to 5. I'm sorry, 4 to 5. Yes. So, well, it's up to the
Thank
board
you.
whether they
Okay.
want to make another motion.
Right. I will move to state that ordinance 2657-24 is inconsistent.
Second.
So now a yes vote would be saying, yes, it's inconsistent. This is the reverse of what we just did.
Okay. Corey Biller,
Yes.
Allison Canfield,
No.
Michael Cohen,
No.
Deborah Nevis,
Yes.
Frank Sagamundi,
No.
Sujatha Shan,
Yes.
David Cosgrove.
No.
Gaston Halbert,
Yes.
Betzel.
Yes. Okay, so now we have moved.
That was it, so it was 5 to 4?
Yes,
Okay, yeah.
and acted to state that it's inconsistent with the master plan, so the note goes back to the TC, and they can still take action.
Yes, we can.
Yes, but they can proceed accordingly.
Well, you will still have a public
Correct.
meeting
Yeah,
and
yeah,
hear the input, and then either amend and then act on it, or act on it.
And again, I apologize, since it's my first meeting and our first master plan consistency review together, do you want the resolution memorializing the one page with the word inconsistent as opposed to not inconsistent, or a letter from our clerk? Either is acceptable. We do the resolution just as a matter of formality, since it is a roll call vote.
Sure, we can have a resolution that just basically matches what we have. It's something that we previously have not done as a board, but I think your recommendation is just to do it to formalize what we just did, because it is a.
And I would say, since the vote is always not inconsistent, we should probably leave it in the resolution that way.
Well, what I'm saying, it's 5 to 4 that it's inconsistent.
Inconsistent or not
Yeah,
inconsistent.
yeah, I just took out the word not.
Okay.
So do we need a motion and a second to do that?
Oh, no, we just did it in the memorializing.
Okay.
That's why I pointed out that we had a resolution to
Gotcha.
memorialize, so you could do it in one vote should you so desire.
Just looking over the stuff, I wanted to make a comment to make sure that we did include a comparison, or at least somebody looked at the short-term rental ordinance that we put into effect not too long ago. Because I know there was this reference to kitchens and serving food, and then in this one, there was also to non-kitchen facilities. And I'm not sure if that is consistent in itself, but just to take a look at it to make
Oh,
sure
I see what you're
that
saying.
we've got
Yeah.
everything lined up.
Sure, we'll take it. Thank you.
Okay, we have another ordinance.
We do, yes. So the second ordinance on referral this evening is ordinance number 2658-24. This is an ordinance seeking to amend the historic preservation section of the DRZ, specifically creating a new framework for demolition reviews. We have kind of a long summary here. I'll read through some of it a little bit, just to kind of give you a general framework. But, you know, kind of in summary, and Ms. Canfield can certainly opine a little bit in her role for HPC. The township presently, for landmark properties and landmark districts, they're encumbered by a historic certificate of appropriateness review process for modifications to buildings. The ordinance before you seeks to create an additional review process for total demolition. So this is only for applicants seeking to completely demolish a historic resource that's been identified in the historic preservation element of the master plan and has been surveyed for historic value. So the ordinance essentially creates a demolition review framework for those properties that are identified in the historic preservation element of the master plan and have been surveyed for historic value. With the survey on file with the State Historic Preservation Office. It requires an application to be made to the HPC, prior to issuance of a total demolition permit. So this does not encumber the properties from against any other modifications. They can, replace siding, windows, other things. This is only applicable to total demolition.
Is total demolition defined? Because I know sometimes you see these houses in a corner is left or something.
Total demolition is defined within the ordinance. I can pull it up and read through that in just a moment. This demolition permit ordinance is modeled after an ordinance that I wrote for the Township of Montclair, similar situation, which saw a propensity for a loss of historic structures and resources. So there is a total demolition review there as well. And this is the same framework ordinance that has been introduced here.
If you can just clarify, it seems
Sure.
like if something is already designated in the historic, wouldn't, they can't just go and demo it, right? I guess what is
Correct.
this
So,
adding
right.
if
So-
there isn't?
So existing designated properties, existing landmark properties are already subject to a total demolition review through a
Right.
certificate of appropriateness
Okay,
process.
this would be
This
full.
expands just the total demolition review process to those properties that we identified in the historic preservation element of the master plan that have been surveyed for historic value,
So these
They're
are ones
not
that are-
part of those districts.
that have not been designated.
So approximately how large is that?
That-
What,
So that is a number that we still need to the township committee had the same request of me last night, and that's a number that we will have to figure out, because it's not the full set of properties within the historic preservation plan
Okay.
element. It's just those that have been surveyed for historic value.
Clarification, the element of the master plan, these properties are in the queue per se. So we haven't actually had the funding to research whether or not they are still historically significant. So what this allows us to do is to do that if it comes for a full demolition. So as far as however many are listed in the element of the master plan, doesn't necessarily mean that's how many we have. Those are just properties that have been identified since, 81? The resources to which were recommended to be designated at some point in time. But some of those are not salvageable anymore, so we don't know that yet. So again, this is about not getting them designated yet, funding not to do that, and that they are on the element of the master plan of resources, historic resources that have not yet been either designated or identified.
Can you go over the timing, because now I'm confused, right? Because you just said they have to, so I have a property, I want to demolish it. It hasn't been surveyed yet, but then you're saying by asking for the demolition permit, that could spur you to do
Yeah,
a survey.
I want to just fix nomenclature a little bit. Ms. Canfield is referring to a nomination report and a nominating process for designation. Survey is just, a historic preservation expert looking at a property and determining it has value or may have value for historic preservation purposes.
So I guess I'm trying to understand, so the percentage, most of the properties that are in the plan have not yet been surveyed. Is that correct?
No, that's not
Oh,
correct.
that's not correct. Most
That's
of them
not
have been surveyed?
Yes, quite a few of them have been surveyed
Okay.
at one point of time. You know what I mean? Whenever they were
Mhm.
surveyed. Do they need to be updated? Probably, but at least we have some record, and that's why they're on the element of the master.
And that would protect them from being demolished? That would be sufficient?
It wouldn't, it would just subject them to this additional review process
Well,
for
the review,
total
well,
demolition only.
To be demolished as of right, I guess is what I'm saying.
And who would pay for this additional review?
There's it's an application, and the application is submitted to the Historic Preservation Commission, and they facilitate the review of the application.
So they would cover the cost of this review. It would, say a developer or person comes in and says, I want to demo and rebuild this home. And someone says, well, actually, you're on this list. I know you're not designated as historic, but you're in this area. So it triggers this, now you have to.
There's an application form, right, and
So now,
associated fee.
so they have to fill out the application,
Mhm,
pay the
mhm.
fee, submit it to the historic. And then
Correct.
the Historic Preservation Commission pays for the survey? Who pays to have this?
So, no,
And
so
then
there's.
now the applicant now
There's an
has to-
existing survey that's done. So that's why we need to separate the nomenclature a little
I
bit.
just want, yeah, I
So
understand.
the surveys that Allison is talking about is there throughout time, people have surveyed and looked at historic properties, and surveys are collected and collated and cataloged at the State Historic Preservation Office. They have all the surveys that have ever been looked at for any historic property. What Allison is referring to as far as the designation process is a nomination report. That's a locally required report for landmark process, whereby somebody has to do research on a property and identify the 8 substantive criteria that the property meets locally to be landmark listed. That is a separate document that has not been done, and that's not part of this process. I don't want to conflate these two processes. So we're just establishing a total demolition review just to those properties that have been looked at some point in time by the Historic Preservation Office files. There is a document that exists that, this property was looked at. It may have historic value, so we should look at it before it's torn down to see, if it warrants preservation or protection at some point.
Yeah, I
from
think it would be
demolition.
helpful to know how many homes.
And yes, so-
do the
and
people who live in them
piggybacking off
know
that,
if their home has been surveyed?
So the ordinance also sets forth a full notice requirement. So all property owners, effective 90 days after adoption of the ordinance, would have to be notified by certified mail so they would know. And it is only applicable, and I want to be very clear, it's only applicable to total demolition. So
Definition of total demolition.
yeah, sure. Sorry. I'm trying to answer a couple of questions. So it's defined in the new ordinance.
Right, because you don't want to take a home that has historic value and just permit it to be demoed, but it's.
I just also don't know if somebody can find a loophole, because I just feel like I always see some like,
Tack
yeah,
points.
like a chimney or some piece of the corner and then like,
We'll
oh, we
keep
don't.
it, and it's not a total demo. This is total.
And I also want to just note that there is an exemption process for unsafe structures or properties that have been deemed unsafe or a public hazard by the construction code official. Those would be exempted from this review process, and that demolition permit, obviously it can be issued in the interest of protecting public health, safety, and welfare. So I just want to note that.
Allison, in the case of like the application that happened last year, there was a home that had some historic character, but they were gonna do a demo. Is this, like that kind of, this would kind of protect from that, like our town?
Yes, in other words, it's been surveyed, and forgive me, because I kind of confused everybody, but
That's okay.
the survey at one point in time took funding to do a survey. But the more recent surveys that we've done, of course, we're all familiar with, we did a downtown survey. And again, that's all done already. So what we're trying to do is just make sure that, we're protecting these properties, and right now, with the survey done, we know they're historic. We don't know condition, we don't know necessarily, everything about them, which then is the more extensive designation process. But right now, we aren't able to protect some of the pieces that are already on the element of the master plan in the queue as to that they should be possibly deemed historic.
Gotcha.
So,
And unrelated to whether it's consistent or inconsistent with the master plan, ironically, you can have a house that may be deemed historic, but has been gutted on the inside and looks like nothing like what it used to, and it's.
and a good example, if I can throw, the house that was on Old Short Hills Road that I think we subdivided that property.
The
It was
retaining
not,
wall.
yes, I think I did come in front of this committee and say that the house.
And that, if I may, that was a prior application that was decided in more than 45 days has expired since that decision by the board, since the publication of the resolution of the board?
Yeah.
Yes.
Okay, thank you. Please continue.
Now you can talk.
Stopped me before. No. So, I mean, that's a good example of that it needs to be prepared for.
Yes.
Before, yes.
So it's been surveyed already, and then when they applied for demolition, there's a next step that takes place where it's studied further.
The application for total demolition to the Historic Preservation Commission is reviewed by the commission with the applicant present. That's where they can share details on, issues, structural issues, and kind of convey the situation to the commission, and then the commission would render that decision. And the ordinance also sets forth an appeal process, so the HPC can appeal, the applicant can appeal the HPC's decision to the Board of Adjustment if they feel that it was an incorrect decision.
So
Total demolition, yeah, I know that just before. Okay, so the definition for total demolition and totally demolished. This section definition shall be applicable to the razing, dismantling, destruction, removal, or demolition, collectively referred to as demolition, of all or substantially all of any historic resource, including any publicly visible facade, including removal of a building site or structure from its site, which may or may not include the foundation. Substantially all of a building, site, or structure means at least 50% of the exterior walls or publicly visible facade wall as measured by the exterior surface area of the building, site, or structure. Any demolition, partial or total, proposed within 5 years of a previous demolition permit issuance for the same property will be considered cumulative with respect to the percentage of exterior walls of facade demolished or removed when determining whether total demolition is sought.
So just leaving the chimney that Corey is talking about is not acceptable. That would
that
not.
counts as total demo, yeah.
Correct.
Right, and you can't do two sides and then 5 years, 2 years later do the other two sides.
Right.
So they would protect that as well.
Yeah.
So it sounds like the survey sort of puts a pin in the property. And then if someone applies for demolition, it kicks it over to historic because this pin has been put in.
Correct.
And historic then says, okay, this is one of the houses that we've surveyed and has been shown to be historically significant, however you want to put it. So therefore, they need to come before us before they just take
The
a
whole thing
wrecking
down.
ball to it.
Mhm.
And then we will hear their application and we will make a determination as to whether or not this is a property that we're gonna say no on demolition, or yes, they can go ahead and demolish it.
Yeah,
Is that
I just want to change the we to the
We.
HPC, not
That's-
this we.
That's what I meant, sorry, I
Yes.
was talking as an HPC person.
That's correct, that's correct.
Okay, so that's kind of what
That's it.
we're talking about.
Exactly,
Okay.
exactly. And I like your characterization of put a pin in it is exactly correct. So,
That was a pretty substantial list. It wasn't, the number of designated properties is a smaller list, but then there were a number that.
so yeah, and it's only the ones that have been surveyed, so it's the ones that have the pin in it. So there may be some properties that, right, just identified that, may be aspirational, but nobody's looked at those yet. So that's where, and the TC had the same request, we're gonna curate that list so we have that to kind of share out the number. And as I mentioned, there is a notification process set forth within the ordinance to notify those property owners that they're encumbered by this.
If this passes, that would then, I would think, spur the HPC to survey those other ones that they haven't
Sure.
gotten around to survey, so that, ultimately that list would be complete.
Is there a way for potential purchasers to have this list? Like, because if the current owner doesn't notice, I assume there's some place that some potential purchaser of a property in the future.
Sure, the ordinance sets forth that the building department will maintain that list and have that list available. So, and I'm sure that could also be published on the website for availability. So I know, just because of my former Montclair hat, they have now put the demolition overlay on their zoning map. So folks can see that when they go to the zoning map, which properties are subject to demolition review.
And of course, again.
But it's not an overlay, it's specific document.
It's not.
Sorry.
No, you're.
Yeah, it's more for utility for,
Okay,
as far
I was
as
like, wait, but
information.
it's-
It's not an overlay zone, but
Yeah,
they're
yeah,
just
yeah.
conveying the information in their zoning process.
I just want to remind everyone then that, of course, the goal the current jurisdiction of the board is to make the determination whether it is not inconsistent or consistent.
Yeah, so I can move into the consistency review now, unless there's any other
Let's
questions.
do that, because we're starting to get late.
Yeah, okay. So let me just flip back to here. Okay. So relationship to the master plan. So the ordinance, as discussed, advances the following objectives and recommendations of the master plan reexamination and update. One, protect the character of established residential neighborhoods and encourage land use and development at an appropriate scale and density. That's objective 1.01, page 43. With Millburn's history as an established suburban community, much of its built environment and part of the character that make it an attractive place to live is its historic building stock. Providing regulatory oversight of such historic resources is a mechanism to protect the township's historic character. Two, recognize and encourage the preservation of areas, structures, and sites of historic interest. That's goal number 5 of the master plan on page 45. Encourage the preservation and restoration of structures of historic and or architectural significance. That's objective 5.01 on page 45. And encourage the Millburn Township Historic Preservation Commission to conduct reviews of neighborhoods and structures to determine if there are additional areas or sites which deserve protection under this Township's Historic Preservation Ordinance and make corresponding recommendations to the Township Committee. That's objective 5.02 on page 45 of the master plan. This ordinance amends the HPO to protect an expanded set of Township's historic resources, encouraging their from total demolition, encouraging their preservation and restoration by protecting them from demolition. And then the final section of the master plan, which has a relationship to this ordinance, is to monitor recent tear downs and new construction in single family districts to determine whether additional zoning modifications are necessary to protect neighborhood character. That's on page M1 of the implementation matrix in the master plan. When historic buildings are demolished, it is often to make way for new construction of modern single family homes. Regulatory oversight of demolition of historic resources will help to mitigate this trend and evaluate historic resources.
Is there a time frame in which the review committee has to meet?
45 days.
45
Yes.
days, thanks, I missed that. Okay. Does anyone want to take action on this proposed ordinance?
I'll try again.
Okay.
That this ordinance is not inconsistent with the master plan.
Second.
And do you want to,
We have the same resolution, we changed the names to protect the innocent, I guess. No, but to change the name of the ordinance and the number, of course, but it's the same ordinance. It reads not inconsistent, at least for now.
okay. If we vote yes.
And if you vote yes, that it'll remain that way. I would just ask Eileen, when she modifies the other one and this one as well, if you could just put in the introduction, the date of introduction by the governing body for each ordinance. I didn't have that handy.
Okay.
Yesterday.
So it's a motion and second to find it not inconsistent with the master plan.
Cory Biller,
Yes.
Allison Canfield.
Yeah.
Michael Cohen.
Yes.
Deborah Nevis,
Yes.
Frank Sakamondi,
Yes.
Sujata Shan, David Cosgrove,
Yes.
Gaston Halbert,
Yes.
Beth Zoll.
Yes. Great. Inconsistent for ordinance 2658. There were all yeses.
Oh, yes, it's okay.
Yes.
I'm sorry, Mike. Couldn't hear what she said.
It was okay. Our next meeting is Wednesday, February 7th, 7:30 p.m. We will have the open space discussion, and I would like to also use that part of the time to talk about some follow-ups from the last meeting we had. A few items were brought up and discussed. We've started to talk about them with the professionals and with Eileen, so I'd like to provide an update to everybody about what we can do for this year.
Is that including like making this meeting available on Zoom? Is that-
Yeah, we're gonna talk about that, and making things available electronically, and bylaws, and a few items that came up, we've been starting to advance. Okay, I move to adjourn, give a second.
Second.
All in favor?
Aye.
Good night.
Oh, yeah.